of the Public Accounts Committee can advise members that all mobile phones must be set to airplane mode and or silent or turned off. It's not sufficient to put the mobiles onto silent as they continue to interfere with the Assembly recording. This session is being recorded in video and audio and can be accessed live via online streaming either on the Assembly website or Democracy Live. Members' apologies, I think everyone's here today. So agenda item 3, minutes of our meeting on the 22nd of June. Can I refer members to the draft minutes of our meeting on the 22nd of June at pages 64 to 66 of the pack? Members, you contend that's an accurate record of that meeting? If so, I'll sign as being correct. Members, matters arising from those minutes, I've nothing. Any members? Okay, members, agenda item 5, correspondence. Can I refer members to the tabled email correspondence from Mr Nigel Wilson in respect to the closure of a school his children were attending in County Armagh? Mr Wilson has written to the Education Minister to ask that the role of the department within their planning process should be investigated. He has also provided an alternative proposal to CCMS, which Mr Wilson advises has not been considered. Members, can I just advise this is a specific individual case on a development proposal, and it's not within the committee's remit to comment on the merits or otherwise of this individual case. However, Mr Wilson does make a number of comments which resonate with the PAC report on sustainable schools, which was published towards the end of the last mandate. Members, as this is a live case, can I just ask that we note the correspondence from Mr Wilson and forward it to the Education Committee and notify him accordingly? Members content?
Great.
Okay. Members, agenda item 6, inquiry into the governance of land and property in the Northern Ireland Housing Executive in relation to correspondence. Can I refer members to the correspondence from the Northern Ireland Audit Office at pages 70 to 72 in respect of the issue raised at the meeting on the 15th of June regarding whistleblowing correspondence that the committee received in regards to the inquiry into the governance of land and property in the Northern Ireland Housing Executive. A copy of the letter issued by the committee can be found at page 73 for information. The Northern Ireland Audit Office correspondence advises that the issues raised by the whistleblower are separate and distinct from those considered by the committee at the time, and that would not have made any difference to the outcome of the findings of the report. Members, if you recall, that was our concern if they were, or they would have had an influence on the final report. Audit Office is advising they're not, so are members content to note this correspondence? Great. Okay, members, agenda item 7 is an inquiry into the Northern Ireland Courts and Tribunal Service Trust for the year ended March 2013. Can I refer members to the correspondence from the PSNI at pages 76 to 77, which provides an update on the recent conviction of an ex-constable for offences committed whilst he performed the role of a warrant officer. The correspondence also advises that the Fine Enforcement and Collection Service will be formed in early 2017 and should alleviate such incidents happening again. Oliver, that was direct response to the query that you raised. Had the officer been taken to court or had he been prosecuted? So, members, any comment on that correspondence?
Sorry, can you read out the last bit there, Chairman?
It's pages 76 to 77, Oliver, is your relation to the police officer and the fraud.
Thank you.
That's noted there. Members content to note?
Noted.
Great.
No. Okay, Kieran, can I just thank you and your team at this time for
Very much.
your support so far? And just take a pause, members, to allow a change of witnesses. Okay, members, move agenda item 8, inquiry into managing legal aid and evidence session. Before the session commences, can I ask members if they have any declarations of interest to declare? Okay, members, content. Can I welcome Nick Perry, the Accounting Officer for the Department of Justice, David Lavery, Head of Access to Justice from the Department of Justice, Paul Andrews, Chief Executive of Legal Services Agency NI, Mark McGuckian, Head of Legal Services Division, Department of Justice. Members, there are pen pictures of our witnesses at pages 79 to 83 of your pack. Members, we have agreed our order of questioning, so if I just move, I think, to welcome our witnesses here today. Gentlemen, you are welcome to this inquiry session, the first of our new Public Accounts Committee. So it's just to set a context, members. The 2011 PAC report noted that there was a need for significant reform of the legal aid system in Northern Ireland in order to bring expenditure under control. But we have noticed there has been a lack of traction with a number of recommendations that are still outstanding. And the most significant reforms implemented since 2011 have been reviews of the enumeration agreements for publicly paid legal representatives in criminal cases. The fees for Crown Court cases were subject to review in 2011 and 2015, and the fees for Magistrates' Court cases were reviewed in 2014. These reforms had the effect of limiting the rises of expenditure on criminal legal aid between 2000 and 2010. But by looking at the figure 1 of the CNAG's report, it appears that the Department has failed to reduce the overall expenditure on legal aid. Members, just to move into our question, and can I ask, I suppose, Nick, you think it is acceptable that so many recommendations from the PAC report from 2011 in regards to legal aid are still outstanding?
Thank you, Chair. Perhaps I could just begin by saying that the Department accepts the recommendations of the Audit Office report. I mean, I acknowledge there are observations that there is still more to do, that some initiatives have been delayed and that we've faced challenges on the way, but a majority of the recommendations in the 2011 report, I think, have been completed, and all the others are being taken forward. I think it's important not to lose sight of what's been achieved since 2011, because significant progress has been made. Through standardised fees, we've successfully stabilised criminal legal aid, despite a significant rise in the number of Crown Court cases, and it's something the report recognises. And in steady state, we will have reduced the cost of criminal legal aid by £15 million a year without any impacting significantly on access to justice. We've put in place a clear statutory foundation for the reform of civil legal aid, and we'll be introducing standard fees in family cases in the first half of next year, a major change with more significant reforms to follow. And that will, in addition, strengthen our ability to tackle fraud. We've reduced the use of two counsel in the Crown Court by almost 2/3. We've ended very high cost cases in both the Crown and the Magistrates' courts, and we've agentised the Legal Services Agency to improve efficiency and tighten accountability. And we've done that while protecting access to justice for the people in our society who need it. So against that backdrop, Chair, although in one or two cases in relation to one or two of the recommendations we haven't quite made the progress we'd wished, I think in terms of the fundamentals of reform, a great deal of progress has been made.
So in regards to, I suppose, your last sentence there, Nick, do you think it's acceptable that after this period of time that we're still in the state we are?
Well, I think the legal aid system is in a much better shape than it was 5 years ago. The reality has proved that the delivery environment for these reforms has been extremely complex, both in terms of the policy formulation and in terms of implementation. There are a number of reasons for that, and I dare say the committee will want to explore those in detail as we go through. But I think in terms of, it was the criminal side of the legal aid that was in the most need of urgent and radical reform, and it has received that reform. And we now have firm plans. We've laid the foundations for a similarly fundamental reform on the civil side also. So, as you say, Chair, there are one or two issues, areas where we haven't quite made the progress we have. But it is, we're on the right trajectory to make progress.
Okay. Nick, I suppose it is something that has just been brought to the attention of the committee today. The lack of those reforms are now leading to the department's accounts being qualified. Do you think that's acceptable?
No, I don't. And the reason this is the first year the department's accounts have been qualified is because the change of status in the Commission to an agency of the department means that the qualifications that exist in the agency's accounts now impact on ours. This is the first year this has happened. It relates to a very specific area, which is the calculation of provisions. There are a number of qualifications connected to the agency's accounts, but we're working very hard to put the mechanisms in place to have those qualifications removed. A great deal of work is going on all of those technical issues, and we can say more about that on the way through.
Okay. Paragraphs 1.4 to 1.8 of the CNAG's report actually examine the legal aid reform programme in England and Wales, which is actually expected to deliver savings up to 215 million each year. What are the barriers to introducing a similar reform programme in Northern Ireland?
Well, we've used the system in England and Wales as a comparator and a benchmark for the system here, but and many of the sorts of reforms that have been introduced in England and Wales have been replicated here. But it is a different system. The society that we serve here with our legal aid arrangements is a different structure in some respects to that in England and Wales. And I think the reality is that in England and Wales there's now a real sense that they've gone too far in terms of both straight cuts to levels of remuneration and in taking areas out of scope as far as legal aid is concerned. And I think both the Audit Office in England and Wales and the PAC in Westminster have criticised some of those reforms as having gone too far and not demonstrating value for money. So we have used England and Wales as a benchmark, but it isn't an entirely appropriate guide for everything we've done here, and the arrangements we're putting in place here, I think, are bespoke for Northern Ireland.
Chair, could I also say that some of the changes in England and Wales, I think politically would be likely to be unacceptable to this Assembly. For example, the previous Justice Minister has made a decision that private family law would remain within the scope of the legal aid system. As you know, in England and Wales, they removed private family law cases from the legal aid system, and that appears to have been quite repercussive in displacing unmet legal need into other areas. So, for example, it's been damaging to the Law Centre network in England because they were reliant on the fee income from having solicitors doing that work, so it's been quite repercussive. So at a political level, and I've no reason to think that the current Justice Minister will depart from this, it was felt that it was appropriate to give coverage for private family law cases in Northern Ireland. And a second example of a different approach, maybe in answer to your question, is that we have looked a number of times at contracting for legal aid as a way of procuring services from lawyers. And indeed, this committee, when we appeared in 2011, asked us to keep the possibility of contracting under review. But it's something that although we've looked at it, we feel would be damaging to the structure of the network of small solicitors throughout the province. We simply don't have the scale of practices in Northern Ireland that allows the benefits of contracting. In England, you get these almost like legal aid factories in the big conurbations. In Northern Ireland, you have a completely different structure to the legal profession, particularly the solicitor's profession. And I think it would be quite difficult to give effect to contracting, and it would be quite damaging if, say, one firm in a particular part of the country were to hoover up all the legal aid work.
Okay, Dave, I think we'll cover that in some of the evidence stations. In regards to you say there not been the political will. There has been a political directive to change some of the legislation in regards to legal aid, which has been blocked a number of times. Can I ask how many changes to the legal aid system that was proposed either by the Assembly or the Justice Minister that have actually been blocked either by judicial review or other methods?
There have been challenges to some of the measures we've introduced. There was a judicial review, as the committee will know, last year to changes we introduced in the fee structure for lawyers doing cases in the Crown Court. We actually successfully resisted the greater part of that challenge. Then, when that didn't work, the lawyers withdrew their services and went on strike. So we have, as Nick has said, encountered quite a challenging environment, but we've been able to deliver the greater part of those changes, notwithstanding that challenge that we encountered.
How many? That's what I'm asking. How many changes, either recommended by the Justice Minister or by the Assembly through legislation, have been blocked
Well,
or
none
challenged?
have been
Or challenged?
none have been blocked, Chair, but one was significantly delayed for the better part of 9 months by the disruption in the Crown Court, and we ended up going to mediation to sort that out. And thinking back a number of years, in 2012 there was a similar legal aid strike, which took a number of months to resolve. So nothing has been blocked, but there have been there has been resistance, significant resistance by the lawyers who are the suppliers of legal aid.
Okay. And after that 9-month period, when things did resolve, what was the cost savings out of that change?
My colleague, Mr. McGuckin, will perhaps give you the detail, Chair.
The savings which we expected to deliver from those rules are about 4.9 million per annum when they're fully operating, based on the level of spend in 2013-14, which was the base year.
Okay. That base year, I think, is paragraph 3.23, page 23 of the report of Access to Justice Report 2011. That was the estimate of 5 million then. It could have been reformed. When do you think those will be in place?
Sorry, I'm not quite sure that I understood the question there fully.
Sorry, you mentioned 4.9 million. I'm referring, there's 5 point, that figure you're already referring to is in paragraph 3.23, page 23 of the Controller and Auditor General's report. And I'm asking you when you think those recommendations, you're talking about recommendations and savings that may be made. Can I ask you when they're going to be made?
Sorry, the savings which I was referring to were the savings which would flow from the 2015 and subsequently the 2016 amendments to the Crown Court rules, which are the criminal fees. Yeah. The £5 million per annum, which is referred to in the report, is in relation to fees or savings against the fees in civil remuneration. Yeah. We are in the process of, we're taking that forward on a phased basis, focusing initially on family matters within all court tiers, and that's quite a complex process in terms of introducing standard fees and augmenting the existing standard fees that where they are already there. We're in the process of finalising those arrangements, and we'll be returning to the Justice Committee and the Assembly in the autumn with our final proposals for that section to implement the new fee scheme from the 1st of April next year. And then phase 2 and 3 will follow from that. The first phase will be about 70% of the costs involved. So we expect those to start to kick in from April next year.
And are you expecting any challenge to those?
Well, we've worked very hard to ensure that we've got a very robust approach and agreement as far as we can. Certainly in terms of the methodology, there may be some dispute over the levels of fees, because in all of these we're seeking to introduce standard fees in order to simplify the process and to give clarity. But as well as that, as the report indicates, we'll be looking to achieve some savings from it. That means cuts in fees, and there may well be disagreement over the level of cuts in fees. We would hope to avoid challenges by the work that we have done to this point in order to get a degree of agreement on them.
Okay. Trevor, do you want to come on it?
Yes, thanks, Chair. Welcome. Nick, whenever you made your introductory remarks, you sort of painted a picture of steady progress, the laying of foundations, I think you said. Yeah. But this appears to be a process that's been going on since about 2002. And but the reason we're here, in my opinion, is because of the lack of progress, not because of the achievement levels. So my questions are around the remuneration rates and the progress. So it does seem to me, frankly, I'll say it straight away, that the legal profession seems to be running rings around the department down the years. But so the first question, the agreement between the Bar Council, the Law Society and the departments around the 2015 rules, yes. But to what extent did that agreement impact on the reduction in fees that were intended by the 2015 rules?
Yes, there was some reduction in the level of projected savings, I think, from, and Mark will keep me right, I've got this wrong, was it from 7 million to around 5 million as a result of the adjustments we made as a part of those discussions. But 2 important points. The bulk of the savings were retained, and the principle underlying the introduction of standard fees, which is the most fundamental change, was protected. So in both those respects, it was a successful outcome from the point of view of the department. And the court, I think, found in the department's favour on 3 of the 5 grounds that it was considering. So
I can't hear that.
It's very hard to hear.
Nick, could you... Trevor's having trouble. This just as him.
I think we're all having a wee bit of trouble hearing each other.
Okay, sorry.
Yeah.
Did you hear any of that? No. All right. As I said, the reduction in the projected levels of savings was from about 7 million to around 5 million as a result of the arrangement or the agreement we came to with the professions. The important point from the department's perspective was that the bulk of the savings were preserved as a result of this process, and the principle underpinning the reforms, particularly the use of standard fees, was endorsed by the court. So those were important outcomes from the point of view of the department. And there was also, of course, a public interest in seeing the courts resuming business.
But also, Mr. Lunn, if you think about it, when we were last here in 2011, the criminal legal aid system still was dominated by what's called very high-cost criminal cases. That was a special scheme, where a small proportion of the cases were taking up a huge proportion of the budget.
Yeah.
And obviously we were encouraged to address that. That was one of your recommendations. You also had a system where a lot of the fees for regular Crown Court cases were assessed after the work had been done by the taxing master. So we had a lack of predictability. In the last few years, that has all been addressed. The very high cost case scheme has been removed. And we've gone, as Nick was saying, for a standardised fee system.
There's an exceptional cost.
There's yes, there's an exceptionality scheme, but it's a very limited scheme. You're not allowed the threshold that you have to negotiate to have a case regarded as exceptional has been drawn based on the lessons learnt with the very high cost scheme.
Well, you referred to it there. This line that the integrity of the 2015 rules was maintained and expect significant savings to be delivered. In what way was the integrity? Could you explain that line to me? Because it comes off the tongue beautifully, but I'm not quite sure what it means.
Well, I think it's really the point David was making. The part of the challenge in that court case was to the whole concept of standard fees and their suitability for remunerating various kinds of legally aided work, and the court upheld the validity of that approach.
And indeed, the current report by the Audit Office explicitly encourages to use that methodology going forward. It is a significant step change. It means we will have cost control, budgetary predictability, and hopefully value for money. So the Audit Office have looked at this and have said that standard fees is the right approach to use. And that's why Nick said by a small compromise at the end of that strike, we were able to retain the standard fee system. And to some extent, that brings people into a sort of a lobster pot, if you like, a standard fee regime. You can't get out of it.
Lobster pot.
Uh-huh.
But the agreed amendments seem to have effectively reduced the intended savings by about 35%. I mean, that's the deficit between what you meant to do and what actually happened. Do you think that's reasonable, given that the Great Britain rates have been reduced in the meantime as well? And the idea was to bring them closer together.
And we had achieved a degree of alignment, or at least a closing of the gap between the two, until the further round of cuts in England and Wales, which have been the subject of some criticism. But as I mentioned at the outset, Mr. Lunn, I mean, when the 2016 rules are fully in force, we will have taken something like £15 million a year out of the criminal legal aid baseline. And so although we have forgone some of those, some savings in order to have the system working in a slightly modified way, we have preserved the structure which is delivering those major savings without impacting on access to justice.
Daniel?
Just touching on, you're talking about the basic fee there. There's a huge contrast between here and Great Britain, but you're talking about the exceptionality cases or the cases that stand out. But like, can you explain why it is so high here in comparison to the rest of Great Britain? Remuneration.
I think there are a number of reasons for the difference. First of all, we have brought our fees closer to England and Wales, and indeed the most recent round of cuts that occurred in England and Wales were reversed by the Justice Secretary last year, or earlier this year. I think it was in January that happened. So they've actually had to pull back from the extent of cuts which they did introduce. I think there are a number of other factors in terms of the overall difference in costs within Northern Ireland. First of all, our court structures operate slightly differently. In the Crown Court, we have a higher proportion of more serious cases. So in England and Wales, there are a variety of less serious cases which would go and be heard in the Crown Court, which in Northern Ireland would be heard in the Magistrates' Court, which drives up the overall cost within the Crown Court. There are slightly different approaches in terms of how representatives operate and the attendance of solicitors on counsel in the Crown Court to ensure a proper level of representation. And I think the final point is really in terms of the structure of society here and the number of people who are on benefits, which happens to, which creates you would tend to have a slightly greater proportion of the population entitled to free legal aid or legal aid of some variety, and that's what helps to drive the overall costs.
Even after reforms, like, it'll still be significantly higher, but in percentage terms, what is that?
The significant...
The cost, overall cost, remuneration rates in Northern Ireland, even after reforms, it's likely to be significantally higher.
Well, they will be higher. I'm not sure that we can say they're significantly higher. The structure of the systems as they operate are different, so it's challenging to do a direct comparison on them. We are informed by the rates which are paid in England and Wales through their graduated fee scheme, but they aren't directly replicable and comparable to the structures that operate in Northern Ireland. So you can't, and I don't think that there's a direct comparison in the report in terms of percentage terms that people have been able to identify, because there are differences in the structure and in the schemes.
Okay, Daniel, Trevor, you want on there just?
Just in your previous, not that last answer, the one before that, it seems as if you're nearly making an excuse for the system we have in Northern Ireland. And that, I don't think necessarily that's what Daniel was asking you. So we're really looking for the rationale why we have such a system in Northern Ireland. Because that was part of the reform, that our system should be made different. But you actually just made an excuse for it rather than giving a reason why it is such a system.
But there are three...
Sorry, if I can let Mark answer that.
Well,
It was Mark, sorry, it was Mark.
Yes.
It was directing the question to you, David. So
yes, that's fine.
And it was Mark give the last answer, so I'd like
yes,
Mark to answer that one.
perhaps I might supplement his observations.
Well, each system in each jurisdiction has developed on its own basis through its own legislature and through its own analysis. So our system has developed in a particular way, reflecting the way that the court operates, reflecting the way that the legal profession is structured as well to a certain extent, and reflecting the way in which government within Northern Ireland has decided that the citizens should be supported when they need legal advice and assistance. Should that be in the criminal courts when they're facing charges, or should that be in terms of taking forward...
But sorry, I think you're still missing the point. The whole idea of reform was because we knew the system had to change. The system, to drive that change, should have been come from the department. So really, why have you failed to turn that system around rather than make an excuse that we have a different system than the mainland?
Well, I was asked for a comparison in terms of how the system operates in Northern Ireland and how it operates in England and Wales. In terms of the overall costs, yes, we have driven down costs. We've driven down the average cost. That's acknowledged in the report as well. We had, in terms of the focus of a large part of the focus of this report, which is on the Crown Court fees, we had a very significant increase in the throughput in the Crown Court for a variety of reasons, which we can talk about. But that 62% increase in the throughput in the Crown Court only resulted in a 20% increase in the costs. So you can see that the steps that we took in 2011 had a very significant impact on that, and the further steps which were taken in 2015 and 16 will further assist and drive down those costs. We are approaching this from a standard fee approach and simplifying the system as much as possible so that it's straightforward and clear for those who are operating in it.
Okay.
Might I be permitted just to make one observation? Whilst we might like the look of the cost of the English system, I don't think you'd like the look of it in practice in Northern Ireland. The way the fees are structured, say, for the Crown Court in England, it's only economic for firms to take a Crown Court case if they send a clerk to attend on the barrister at the trial. In Northern Ireland, it's a professional responsibility of the solicitor who's taken the instructions in the case to attend the trial throughout to support the defence. Now, I think that's preferable with respect, and I don't think we would want a system where in England you get stories of even unemployed actors being sent to court to sit behind the barrister. I mean, it's just not an attractive system. We have a professional duty on our lawyers that the solicitor attends the trial. We could take more cost out if we changed that rule, but you as an assembly will have to decide if that's a justice system you want. I've practiced as a barrister in the criminal courts, and the solicitor who instructed me attended throughout and was making a valuable contribution because they know the case inside out. They have met the client from they were arrested in a criminal case to they go to the trial. There's an important role for the two lawyers to provide, and in England that's gone now. I think it's a serious consideration what sort of justice system we want.
An affordable one, I think, is what we're trying.
Yes, absolutely.
Yes,
I agree with that
Mark,
as well.
you referred to in your comments about the average cost coming down. Figure 3, page 16 of the CNAG's report, average cost for legal aid and assistance increasing steadily from 2012-2013. Average cost of the children's order increasing steadily from 2012-2013 to 14-15, and civil and legal aid average cost increasing as well there. So just want to put that on record that the average costs aren't coming down when you take that table into comparison.
And there are a variety of reasons why some of those average costs are increasing on the civil side, and we are currently, and we can go into them. I'm sure it will come up later in the session. We can go into them at that stage, and we are taking steps with our work on civil fees to introduce standard fees, which will help to address that. So that it's
Daniel,
identified.
Just on page 23 in paragraph 3.9, states that following the settlement with the legal profession, the department states that despite these changes, the integrity and Trevor touched this, integrity of the 2000 rules was maintained and expect significant savings to be delivered. But how was this meant to be delivered without the intended reduction in legal aid fees? How was the overall integrity of the rules was to be maintained?
Because the concept of having standard fees was protected. That's I think what we mean by protecting the integrity of the reforms. I mean, part of the challenge to in that case was really to the entire concept of standard fees.
What were the nature of the amendments agreed with the legal profession in the 2015 rule?
President, perhaps I'll ask Mark to pick up on that.
In fact, in the 2015 rules, we've made significant reductions across the board to the standard fees, which were already in place, and we'd made some adjustments in terms of how guilty pleas were operated, and a number of other minor changes. In some areas, for example, we would have protected the fees which are paid for the more serious cases because that's where the additional work was done, and in other areas, and there's a small number of those cases, but there's a lot of work involved in them. Other cases where there's a high volume of cases but less work, the fees were reduced there. Through the process of discussion during the strike and during the judicial review and in the mediation, we agreed to insert back into those fees a proportion of the cut which had been made. And that brings us to the point that Mr Perry was talking about earlier on, where in the 2015 rules we were estimating or projecting a saving of about 7.9 million, and that was reduced to 6.9 million, and that was reduced to 4.9 million through the mediated settlement. So we retained the overall structure of the fees that we had put in place, and we added some of the savings back into the fees again in order to resolve the situation which had gone on at that stage for about 10 months.
Trevor, are you finished now? Yeah. Sorry, I just wanted to clarify one thing. You talked about the exceptional costs system now, and I would accept that it's probably tighter than what the old system was. But just for my information, does that mean that you get a higher rate per hour for doing the work that's necessary, or does it mean that you get more hours at the same rate?
The intention with the exceptionality clauses are where, and I think it's important to actually set the context of this, where you have a case, the standard fees are intended to address all cases on a swings and roundabouts basis. So the standard fee is designed to take a case which might be quite complex or a case which is less complex, and you have a standard fee for it. What has become clear...
Is a standard fee hourly rate, is that right?
No, it's actually a fixed amount of money.
All right, okay.
It is clear that in certain circumstances issues can come together which mean that the standard fee as it currently stands wouldn't properly remunerate that piece of work. So it's the additional work effectively which you are providing an additional sum of money from, which is then very carefully managed and controlled.
Okay. Carla?
Thank you. And just very, very quickly, and I just want you to explain further. You've mentioned the standard fee and the movement towards using a standard fee. Can you just explain what exactly you have been doing and what stage you're at with that?
Okay. In terms of criminal legal aid, which covers issues largely in the magistrates' courts and crown courts, we have standard fees now in place covering all cases going through those areas. In the civil courts, which represents cases in the magistrates' court, the county court, the high court, and so on, there are a very wide variety of different types of cases, ranging from divorce and ancillary relief through to private family matters, through to public family law, where a child is being removed from its parents. So the wide variety of cases there. There are some standard fees already in place in that area, but we are carrying out a fundamental review of all of those fees, and including those which are currently paid on a time and line basis and which are assessed individually, and developing a standard fee approach for those. As I said earlier on, our focus recently has been on the family matters, because that makes up about 70% of the costs, and we'll be moving on to the others we've already started some research on it, but completing those and moving on to them more fully next year.
Okay, so just very quickly, so a fundamental review is being carried out. What stage is the fundamental review at, and when will we actually see fruits from the fundamental review? Can you put some sort of a time scale on it? It's just,
Yes, I certainly can. We are about to put our final proposals to the Law Society and the Bar Council in relation to those family cases and children order cases that I talked about. We will be coming back to the Justice Committee with the details of those in the autumn, with a view to making the necessary legislative change to have them implemented from in the next financial year. We then will be finalising and taking forward the work on other court-based cases as phase 2, which will be taken forward during the course of the next financial year, with a view to having that in place at the end of that.
So ultimately you're talking at least another 2 years? Really,
Yes,
2
in order,
financial
well,
years.
and potentially 3 by the time we've tidied up the non-court-based cases. It is a complex set of cases that need to be looked at, and I think it's important that we invest the time in it to get it right.
Yeah, and I do recognise that it is complex, but obviously it's public money, and we're keen to try and get a handle on it.
Okay. Can I just, you've talked about the changes. Who's responsible for implementing these changes? I'm aware we've heard from you 3, but as Paul, as Chief Executive, who is responsible for implementing these changes?
Well, it's my job to give effect to the legislation that's brought forward, and that's the role of the Legal Services Agency. We work obviously very closely with our colleagues in the department in the development of the scheme and also providing information to support that development. But there's a traditional fault line between the department in developing policy, the agency in implementing the statute that is brought forward. But of course, because we have got the information, we have to work closely with the department in facilitating the development of their schemes.
So who's responsible?
Well, if I chip in there, Chairman, I mean, responsibility varies. The responsibility for the policy around legal aid and for the budget rests with the department. Responsibility for awarding legal aid rests in some cases with the court on the criminal side and with the agency on the civil side. And in terms of implementation, actual practical the operationalisation of the system, then the agency is responsible for that.
So who's responsible for driving these changes?
Well, it's a team effort, but it's the department and the agency working together that are driving that.
So, is there anybody? Are you ultimately responsible?
Well, ultimately, it's the department's responsibility in terms of changing the policy and persuading the Assembly to make the legislative and statutory amendments to permit to change the framework.
But I mean, I would say I have principal responsibility. Nick looks to me to deliver the department's policy programme, including legal aid policy. And then Mark's team designed the system and put it through the legislature.
So it's all designed, it's all on paper. Is it your responsibility to deliver it, Paul?
I have to implement it, yes.
Yeah. Okay.
But I mean, can I add to that? I'm doing all the legwork in terms of the policy development and getting the material through the Assembly. But in that, I am directed and guided by what's called the Legal Aid Strategy Group, which brings all of us together and is chaired by Nick to ensure that there's an overall focus and drive in taking it forward.
Okay, Dagmar.
So why is there a fault line?
Well, there's less of a fault line now that what was the Legal Services Commission has been changed into an agency, and it's now directly, if you like, part of the department and part of the department's management structure. So, but even in agentising, what was the Commission, it was important to make sure that its independence of decision making when it came to the allocation of legal aid was preserved, and special provisions were put into the legislation to protect that and to provide independence around that. But in organisational terms, there is now much less of a fault line than there was.
But there's still a
So
fault.
is there a fault line or is there not a fault line?
There's not a fault line.
There's not, but he said there is a fault line.
Well,
You're
I think
saying that there's not as much a fault line as there used to be.
Well, I think perhaps.
But now there's no fault line.
Well, I think perhaps what we meant was, in terms of a division of function, a responsibility of roles. That I think it's a fault line in that sense.
Sorry, I missed the last point.
It's a fault line in the sense of the agency has a job to do in delivering, but it's the department that sets the policy.
So there is a fault line.
Well, there's different functions.
There's one.
Are you joined up?
Yes.
Yes.
Yeah.
And the difference. Sorry, there is one fault line, and it's an important one, and that is Paul is, as well as Chief Executive, he's the Director of Legal Aid Casework. So he decides who gets legal aid in a civil case. We can't influence him in that at all. And I think that's a desirable thing. The Assembly put that onto the legislation last year. That means we cannot, say our budget's under problems, we can't tell him to turn down the legal aid grants. He has independence in that role. That's what I would call an appropriate fault line. But in terms of legal aid reform, we're totally together because we're all delivering the same programme. But that's one important distinction, Mr. Kearney. The Assembly said the Director of Legal Aid Casework, who decides who gets civil legal aid, must not be influenced in any way by the department, and that's, I
Art,
think,
what was
important.
the overall body you mentioned there? The
Legal Aid Strategy Group.
Legal Aid Strategy Group, and who chairs it, Nick?
I chair that, yeah.
Okay.
And just, I mean, can I add a bit of gloss on to the other comments? Paul and I work very closely together as the policy development and the operational arm. I will, for each of the reform initiatives that I'm taking forward, I will have a project board, and the agency will be represented on that project board in order to bring its experience and its understanding of the practicalities and the implications of the changes. So we are joined up from that perspective. That also helps ultimately from the implementation perspective, because the agency and its staff will be fully aware of the changes which are coming down the line and what they're intended to deliver. Now, that wasn't necessarily always the case, and certainly when in the past, when it was a non-departmental public body, it would have been more difficult to have that sort of relationship.
Is there the skills within the department to drive these changes? Do you have the appropriate people? Skills.
Yes, I think we do. It is a technical area. It is a complex area. I know we've said that several times. So you need to build up experience in the area, and so you can't just throw people at the problem and expand your capacity. But in terms of having teams, including lawyers and accountants and other kind of professional people alongside the policymakers and those who've spent a long time working in the area, I think we do have the skill sets we need.
Okay. Michelle?
You're very welcome, lads. I have to say, like others on the committee, from your opening remarks, Nick, I thought you maybe had wandered into the wrong committee, because we do have figures in front of us that show that the legal aid expenditure is not going down, and we're extremely worried about the amount of public money that's being spent and the amount of confusion that seems to be within the system. One of the things that we're concerned about the pilot exercise that you did, whereby the client's financial eligibility and their lack of compliance with legal aid legislation and the high rates that you had of that. If that's a small sample and it didn't look good, is there a serious level of non-compliance in the system?
I think Paul might be.
I think there's an important point that there is an obligation on the solicitor to ensure that their client continues to be financially eligible to be in receipt of legal aid throughout the life of the case. I think what the review showed was that there was no evidence that was regularly being attended to, and that was one of the lessons we drew from that. As a result of that, we have been running for over 2.5 years now a scheme where we're actually going out and asking individual applicants to fill in a fresh statement of means form so that we can have them reassessed to ensure that the individual remains entitled to legal aid. I would have to say that the outcome of that has been that the vast majority of people remain eligible for legal aid, some of them on slightly different terms than they were originally granted. For example, they would perhaps not be on a passporting benefit, but they are on a relatively low paid job, so they are still entitled to legal aid. I think, and I please forgive me because this is off the top of my head and I wouldn't wish to mislead the committee in any way, but the number of cases where we have found that people were ineligible was a handful, and those cases have been dealt with.
And there, I know you're looking at a formal registration scheme. Would that include audits of compliance and sanctions for non-compliance?
Sorry, I cut across you. Absolutely, that is the nature of it. It is a compliance regime, and there is a very detailed schedule of, can we call it, terms of engagement that we would expect the solicitor to adhere to. We don't think that there should be any philosophical issue with that, because most of them are standing requirements on the professional, from the professional body, and we would expect all firms to adhere to that. When we are in a firm inspecting it, as we did for the pilot scheme which you referred to, we would effectively have a checklist or a compliance checklist that you see, has the client's instructions been fully documented, is the client being fully informed of the conduct of the case, etc. And then, is there evidence that the client's financial eligibility is constantly under review? And I'd have to say we want to be practical about that. We would expect there to be trigger points when there were proportionate reviews of that, but that would be the evidence that we would be expecting to see on file. And in answer to the final part of your question, if there was non-compliance with that, the registration scheme provides that the ultimate sanction is that that provider of service will be debarred and therefore will not be able to provide publicly funded legal service work.
But out of the 12 that were investigated, 5 could only be granted limited assurance. Is that not worrying?
It is worrying to the extent that there were evidence that the practice wasn't as sharp as we would have expected to be. But I think that sent out a message to practitioners in terms of there needs to be evidence that there are things that are done. Oftentimes people say, I did that. You ask my client, and the answer is, we don't want to ask your client. We want to see the evidence of it on the file. So I would expect there to be a greater sharpness of focus on actually ensuring that the evidence is available to support what they say was done.
And then the context of access to justice, and David pointed out earlier, and this committee recognises that we do have a different system here, and in terms of registration, I was concerned that there might be a negative impact on small rural family firms, that we wouldn't want to see a system whereby it was only the medium and large firms that were able to access legal aid for their clients. You could easily put solicitors out of business if there was to be a differentiation. So what was the experience in England and Wales on that, just from a comparison point of view?
Well, can I take it, first of all, and David may want to provide a supplementary comment. Fundamentally, we have no desire to shrink the network of providers. So anyone in your constituency who has legal advice available to them within your constituency, it is not our intention to shrink that. What we're saying is that we would expect anyone who's providing that service to provide it to a certain standard and with certain evidence behind it. We're not expecting anyone to win an Olympic gold at the high jump in terms of an impossible standard. What we're talking about are reasonable standards which we believe, and I think the Law Society accept, experienced and competent practitioners should be adhering to, because a number of the mechanisms that we have in place are drawn from the solicitor's own regulatory framework. So, personally, on behalf of the agency, we have never been about shutting down small rural practices. We want access to justice to be available. We simply want it to be demonstrated to be providing an appropriate service. I think in England and Wales they adopted a different approach because they went primarily to tendering and competitive tendering. You found that an awful lot of small rural firms simply didn't have the volume of business that they could get a contract, and they were lost in the system. I know I happened to meet someone who's originally from Northern Ireland, went to university in England and Wales, set up a legal firm in England and Wales, and had a contract. He was primarily a criminal practitioner, but it's the same principle. And over a number of years, he found that he couldn't run a practice on the contract environment because he didn't have the mass volume of cases that you need to churn through, which I think was Mr. Lavery's point earlier. So I think we're not going down that road. This is an inclusive system of registration. This allows all practitioners who want to continue to do legal aid work to give them that opportunity, but also to make clear the standards that we expect. And we're not expecting the impossible. We're expecting standards which the professional body have recognised and have enshrined for some considerable period of time.
And for the record, I'm keen that it's not just my constituents or my constituents, the firms in my constituency, but the people who live in rural areas have the same access, that they're not been put to the expense of driving to Belfast to access solicitors that might be registered. I think that's all for now. And
Taylor, do you want to come in?
Yeah, just take you back, Paul, to something in response to Michelle. Given the report highlights concerns, I have to say, you said in response to Michelle, over the last 2.5 years you've had fresh applications. You use words like majority of the cases, and I appreciate you're doing that off the cuff. Could you supply that information of that test of the 2.5 years of many applications that was rewritten? How many of those failed? And could you also, then you went on to talk about where individuals would be debarred. Could you actually give us any information in those cases, how many of those people actually were barred as well?
No. To the first part of your question, yes, we will provide that. I just don't want to give you a figure in case it's the wrong figure.
I appreciate that. No,
but it is a handful of cases where that happened. I then need to make a distinction between the second part of your question. The debarring was the debarring of the solicitor for providing work for failing to apply the standard. There is no such power at this point in time. And in fact, in some of the cases, it may well be that the solicitor was taken by surprise because the client hadn't advised them. So I can't answer the second part of your question because there is no power for me to debar someone from doing legal aid work at the moment. That is part of the package of measures that the registration scheme will bring forward. But I'll certainly provide the information, Mr Clark, that you've asked for.
Well, yeah, to the committee, yeah.
Oliver?
You did say earlier on it's not only those on benefits that get legal aid, it's those in low income.
Yes.
How do you set the bar for a low income?
Well, at the risk of reading out the financial eligibility to it, that is probably the simplest way of describing it, Mr McMullen. So there are 3 broad types of legal aid in the civil side of things, and that's what I'm going to address first. For someone who walks into a solicitor's office and says, I have a problem, can you help me? That's typically referred to as advice and assistance, colloquially referred to as a green form scheme. And to be eligible for that, the individual's disposable weekly income has to be less than £234 per week. Their disposable capital must not exceed £1,000. So that's for basic advice as you walk into a solicitor's firm. Moving up the tier of advice to the point where you're actually entering into the court arena and you're going to the lower level courts, the magistrates' court typically, then that's a representation lower, and the financial eligibility for that is similar. The disposable income is still £234 per week, but the disposable capital increases to £3,000. If you're then going to higher courts for representation to the county court or the Court of Judicature, the disposable income is £10,995 as a ceiling. It wouldn't be legal aid if there wasn't an exception, and the exception is if it's personal injury cases, it's £9,937, and likewise disposable capital thresholds are higher of £8,560, or if it's a personal injury, £6,750. That is the statutory scheme in respect of civil legal aid, Mr McMullen, in terms of the entry criteria.
And the £234 doesn't take into account whether you're single, married, family, no family, anything else. It's just a statutory figure.
Because it's disposable income, there will be a tapering to reflect the number of children or the number of dependents in the language of the statute that you would have. So there will be a tapering, but the greater range of exemptions that you can disapply are for full civil legal aid or representation higher, not for the green form, but there is a tapering effect.
And is that documentation to prove that before the courts?
Well, in civil legal aid, the court hasn't a role in assessing financial eligibility. The solicitor, at first instance, would have to satisfy themselves that they have seen evidence, and We expect the solicitor to furnish us with the evidence when they submit their forms. For the higher courts, the county court and the High Court itself, that comes in a very dense document, and that is then assessed by a body which is now part of the Department for Communities, the Legal Aid Assessment Office, and they do an independent assessment of the means. And again, that should be supported with the various documentation, your bank statements or wages slips and that type of thing to support the individual's eligibility.
Okay, thanks. Trevor, quickly on that.
I'm just curious. Sorry, I'm just curious. I was trying to, if I understand, £234 disposable income. Surely that's virtually anyone who walks into a practice. Am I reading that wrong? Am I picking you up wrong?
I don't.
So that's after everything's paid out. There's £234.
No, there's a limited number of things which you can claim for your disposable income. So there was some research done. I confess it's slightly dated, but it's a very complicated area to try and estimate the percentage of the population that might be eligible, which is, I think, is the burden of your point, Mr. Corn. Back in 2010-11, based on the Family Income Survey, which members will be familiar with, it was estimated that 35% of the adult population would be eligible under the Green Farm scheme. So I think that probably just gives a context.
Could you just ask him through the chair, maybe?
Worry we're varying on the...
Well, I mean, if we're talking about the reform of the legal aid...
Briefly, Trevor.
Well, again, can we get the information of what actually makes... what's counted as eligible to allow you to the £235? I'm not asking for that now, but if we could get that supplied.
That's in statute, so we can supply that to you.
Okay. Robbie?
Yes, thank you. Michelle had touched on the statutory registration scheme and some information in and around that. The committee received the report a number of weeks ago, and in 2003 the statutory registration scheme was provided for. So I believe that it hasn't been put in place. Could you explain as to why it hasn't been put in place when it was allowed for from 2003?
Okay. You're quite correct that the enabling legislation was the 2002 Access to Justice Order, and it was enabling legislation for quite a range of reform across the legal aid environment, including the creation, as it was then, of the non-departmental public body, the Legal Services Commission, which took over responsibility for driving forward a range of those things. It was largely an operational body aimed at providing and delivering legal aid and paying bills, but it had a very small policy hub there as well in order to take forward a range of things, including reform of fees and a variety of other issues. And effectively, it was not a priority for the organisation at that time, among a whole range of other priorities, in order to address the registration scheme. Some work was done on it, but it was quite easy and for it to get diverted as other pressures and other priorities came along. Work started in earnest on it, I guess, towards the end of 2010, and the Commission, as it was then, launched the voluntary scheme. But again, it was a bit stop and start. The Commission started a pilot exercise in 2012, late 2012, and into 2013, which has been referred to earlier, and that provided some valuable information, allowed the code of conduct that Paul referred to earlier on to be refined, and at the end of 2013, the department in my division took responsibility for driving that forward. We developed the codes of conduct at that stage and refined the solicitors one and developed one for the barristers, and consulted in that in the second half of 2014. Now, we haven't moved on as quickly with it as we would have liked, and there are a variety of reasons for that. We need to work along with the profession, at both branches of the profession, in taking this forward, because effectively while we are adopting and adapting the current codes of practice and the current regulatory envelope that they oversee, we are introducing additional regulation onto the profession. We are going to require a compliance regime that was referred to earlier on, so that's got an overhead. And effectively, this has to be a full cost recovery model. So that compliance regime will result in fees being paid. So over the last period of time, we've been spending some time refining the code of conduct, getting the draft legislation in place, looking at the cost recovery models and how the fees might be charged. We are now in a position where the legislation, the rules which will be necessary and the regulations which will be necessary to fully implement this have been drafted, and we have proposals for the charging methodology, and we'll be consulting with the profession over the summer with a view to bringing that to the Justice Committee in the autumn to introduce the scheme next year. But to go back to your original question, I think it's fair to say it was a priority among a range of priorities, and it was very easy in the organisation to get diverted away from that because of other operational things which come to the fore.
Yes, thank you for that. And so, if I've picked it up right, it was allowed for in 2003. It was noted on the risk register as red amber, but obviously there's a myriad of issues that need to be addressed and the risk assessed appropriately. But really, it was 2010 before there were any measures really taken to robustly address it. In light of that, from 2003 to 2010, what measures would there have been in place to monitor and give assurance?
I'm afraid that's beyond my...
If I pick that up, Mr Butler, effectively there is an existing regulatory framework for barristers and solicitors, because they're self-regulatory bodies, and there are the regulations which pertain to solicitors in their terms of their code of conduct, communication regulations, their financial regulations, all of which have been in place throughout that period and continue to be in place. Likewise, for the bar, they have their code of conduct for individual barristers. So if there was a concern or a complaint, whether it was a member of the public who was dissatisfied with the service that they had received from their solicitor or barrister, there was a referral mechanism under the complaints procedure of the Law Society and Bar, and that is exercisable whether you're a legally aided client or a privately paying client. So those mechanisms were in place. The Law Society and Bar then have a range of sanctions which they can impose. In a number of instances, something may have come to the attention of the Commission, which it would have also referred to the Law Society or Bar as the regulatory body, and saying that this practice, if it is correct as described by the individual, would seem to be at variance with the regulations, and invite them to investigate that. So there was, if you like, the regulatory side of things, which continues to be in place from the professional bodies.
Thank you.
The other thing, maybe, Mr Butler, to note is Paul can send for files from any firm at the minute. The difference the registration will make is he can do a spot check, he can just walk in. So you're not... Paul asks you for a file, obviously. Doctor the file if you're minded to do so, but this power will allow Paul to send his inspectors into a firm. So it'll be on top of the Law Society's own regulatory regime.
Okay. Michelle, you contend there? Is that enough?
Yep.
Okay, Alex.
Thank you. Moving on to counter fraud. Paragraph 5.5 notes that the measures of the agency have introduced to counter fraud are mostly focused on fraud prevention by assisted persons. What does the agency intend to develop a more balanced approach which would be more successfully looking at addressing the issues of potential fraud by legal representatives?
Thank you, Mr Easton. If I take this at the start, the agency takes any suggestion of fraud, whether it's by an applicant or a practitioner equally seriously. I think the difficulty for the agency when faced with this report is that the weight of evidence that comes by way of referral to us is almost overwhelmingly in respect of an applicant fraud. So I think we just have to recognise the referrals that we do receive and deal with them accordingly. It's not that there is no less vigilance in terms of applicant practitioner fraud. I think the CNAG also fairly indicates that the staff in terms of practitioner fraud are a useful resource, but he goes on to say that it's not an adequate resource in itself. So there's two things significantly at play. We have the reference to the counter-fraud strategy. We have that being embedded within the organisation. We have ongoing training and development. We have the increasing reliance on standard fees, and standard fees significantly reduces the prospects of someone committing a fraud who is a practitioner, because the standard fee is for the work done. And the work that is done, certainly in criminal matters, is directly verifiable because the payment is triggered by court-based offence, and that can be vouched. And there are sampling checks to vouch that to the court records. In addition to that, the introduction of the fees Mr McGugan was talking about in terms of family will provide greater assurance there as well. The two other points that are particularly important is the advent of compliance and registration, which we were talking about earlier, because while the compliance scheme is not a counter-fraud measure per se, it has significant additional values in counter-fraud because it allows us to look directly at the billing mechanisms within a solicitor's firm. It enables us to see how that is translated into claim forms that we have. So the introduction of the statutory scheme, as Mr McGugan said, it is scheduled for the next financial year, and we are already gearing up to have people recruited and trained so that we can be effective on day one. That is an important tool. The second tool is really a digitalisation programme, so that bills will be submitted online and they will be itemised online. And the great advantage of having that facility, which we confess we do not have at present, is that it provides a greater analysis that you can undertake at the point of entry, so that you can double check, for example, if a practitioner was in Court A and Court B on the same day. That is physically possible. If you're running between courts in Langside, it can be somewhat more problematic if it's in different parts of the jurisdiction. So the digitalisation platform provides a very important supplement to the vigilance of staff, which the CNAG has already recognised, but that takes us on to another level.
Okay. So these mechanisms are being put in place,
yes,
which is good. Okay, 10 out of 10. So was it not remiss that there was no mechanisms up to now?
I think there have been mechanisms up to now. I think the argument that the CNAG presents is the adequacy of those arrangements. We have, for example, 2 cases which relate to practitioners that are currently before the authorities in terms of our assertion that there has been fraud. And those cases were identified by our staff.
Okay, is that with the police you're talking about?
Yes.
Okay. Okay. And is there any mechanism for investigation before now into the legal profession for claims and stuff?
There has been since we have a counter-fraud unit. Yeah. We recognise that we need to scale that up, and that is going to happen as part of the compliance regime, because that's an important context in which to place it. But there has been investigations, and there have been investigations into practitioner fraud. The difficulty has been that they have not provided sufficient evidence to allow us to bring them forward as actual referrals to the police.
So up to now there's just the 2 cases? Has there been
I think if you go back in time, this is predating my tenure, there were probably a couple of other cases, but certainly I can directly speak to 2 cases which I have personally referred.
And any of those cases, did they appear in the courts?
They appear in reports because any report of fraud...
Courts?
So courts?
Yeah, they go to
well,
court.
we're in the hands of the authorities as to how that is progressing, but those are the matters that are with the police at the moment.
Okay.
Okay. Trevor, do you want to just quickly on that?
Just to clarify, sorry, Alex,
That's okay.
is there any liaison between your organisation, Paul, and the Law Society in those circumstances? I know you're constrained on what you can do if you suspect fraud by a practitioner, but as you negotiate with the police or the Public Prosecution Service, perhaps, to see if it's worthwhile to take a case, is the Law Society involved at all?
Yes, as would be the bar if the individual concerned was a barrister. The issue then is one of timing and one of release of information. So, for example, in the 2 cases that I've referred to, once they're referred to the police, I will refer them because I also consider it a professional conduct issue.
Yeah.
The police will do whatever the police do, and that's their independent assessment, or the Director of Public Prosecution does, as the case may be. But if we take a scenario in which there is not a prosecution, I have already a complaint with the professional body. I think, in fairness, the professional body will inevitably await to see the outcome of the police investigation before they launch into the midst of it.
Yeah.
But the information that I have provided to the police will, at an appropriate time, be provided to the regulatory body, Mr. Lunn.
Yes, but there could be the circumstances where the professional body, the Law Society or the Bar Council, might consider action, so some sort of temporary action, suspension, pending the outcome of the
And that is why I seek to refer the material to them at the earliest possible opportunity. Obviously, the police will want to have the information available to them before anyone else is alerted to it, as you will appreciate, but it will be referred to them and they can take appropriate action if they deem that to be appropriate.
Alex?
Okay. These cases of fraud with the legal profession, are they referred on by the taxi master, or was it some other?
These particular cases were identified by our staff.
Right.
Neither of these cases were before a taxi master.
Okay. And has the taxi master ever referred any cases for investigation for fraud?
I think the taxi master has a discrete statutory responsibility, which is to assess the work that was undertaken, whether it was reasonably undertaken, whether it was properly undertaken. Taxi master, I think, is under an obligation like any other citizen if they suspect a fraud to report it to the authorities. I suspect in the first instance to the police, but there has to be evidence of fraud. The taxi master, to my knowledge, has not reported such a case to the agency, but I think there's probably a rationale behind that, because the taxi master receives a significant body of evidence as to the work that's done, because when bills go before the taxi master, many solicitors, I'm reluctant to say all because I'm sure there's one somewhere who doesn't do it, but many solicitors will engage a cost store to prepare a bill for taxation, and that will be scheduled. There will be time records supporting it, there will be court orders supporting it, so there will be a body of evidence which suggests that the work has been done. The taxi master's role then is, if there is such evidence that the work has been done, is decide, did you need to take that long to do the work? And did you deploy the appropriate resource in undertaking the work? So the taxi master will be satisfied. I'm not speaking for her, but I'm assuming because of the weight of evidence that's available with the drawn bill of costs that the work was done. It's the reasonableness of the work that is exercising taxi master under statutory duties.
Okay. Paragraph 5.10 and 5.13 illustrate a need for the agency to develop better collaborative arrangements with other public bodies in order to properly prosecute frauds. Can I ask the department to explain what the agency plans to do to achieve this?
Well, perhaps if I start and other colleagues can comment as appropriate. We have had a dialogue for a number of months now with what used to be the Social Security Agency, now Department for Communities, because there's a parallel that can be drawn between the two systems. Not everyone that is in receipt of legal aid will necessarily be on a benefit, but there will be a considerable overlap of clients. So therefore, we are wanting to draw on their experience in terms of their counter-fraud measures. We had a very constructive presentation from them at our audit committee recently, and that's part of an ongoing dialogue. Some of my colleagues who are staring at me at the minute are actively engaged in meetings with counterparts in Department of Communities to try and help work through a calculation mechanism. There's then a separate issue, because I think this is also touched on the report, about the ability to prosecute, because as you appreciate, the SSA had a standalone power to prosecute benefit fraud. That doesn't extend under legislation to prosecuting, for example, a legal aid fraud, which could in fact be a consequence of someone being fraudulently in receipt of benefit. Now, you've noticed from the report that the vast majority of cases where people are prosecuted for fraudulently being in receipt of benefit, they were not in receipt of legal aid at the same time. So we're talking about a small number of cases. But in principle, we have invited the conversation with colleagues from the Department of Communities to see, could we look to see if there would be a mechanism to change the legislation so that there is one prosecution if there is a benefit fraud and a consequential legal aid fraud at the same time. And I think there's a willingness to engage in that area with us, and we're very keen to pursue that.
Okay. In terms of paragraph 5.14 indicates that the agency has not recovered £25,000 of legal aid wrongfully awarded due to a committee required to authorise these recoveries not having ever been convened. What progress has been made to clarify what is meant by the term work in hand?
Well, first of all, sorry about right, I apologise that is the case. It shouldn't have been the case. And the number of cases fell through a net when an external committee was being stood down and an internal committee was being set up. Colleagues have been working through those cases, and we will have completed our review of them by the end of the summer and taking whatever appropriate action emerges from that review.
What about the 25,000?
Well, when I say appropriate action, if we can recover the funds, we will do so. The difficulty is that some people may be on benefits and it would be an unenforceable debt, but that's why I say we have to work through the process, find out where those people are, and then in terms of financial eligibility, and then where possible we will seek to recover the cost.
Okay, so it was basically because there was a committee stood down and it sort of got slipped through the system, is that?
Unfortunately, you have described it to my embarrassment, Mr. Easton, yes.
Like, don't want me to embarrass you more? I'll leave it there, thank you, Chair.
When did that committee last sit?
I think it was 2 years ago. I'm saying that in round terms, but I think it was 2 years ago.
When was it stood down?
Well, that's when it was stood down, 2 years ago.
And how often would it have met before that?
It would have met as and when required. There would have been there would have had to have been a sufficient body of work to bring together an external panel of people to look at. So it probably would have sat, I would say, every 4 to 8 weeks, just depending on the volume of business that there was for it to consider. But that was part of trying to move away from people outside the Commission agency determining the fee levels that were approved, and that was the primary function of the committee. This was, if you like, a subsequent function that got delegated to them.
Right, so the committee stood down 2 years ago?
Yeah.
Hasn't been reconstituted since?
There is an internal committee that is established. The difficulty was that those cases weren't put to the internal committee, Chair.
Just because they weren't, Paul?
You are exposing my embarrassment, Chair. Yes, they were put aside and they were not brought forward the way they should have been.
For 2 years, for 25,000?
Yes. Not bad for 2 years.
Anya?
Yeah, just to go back a wee bit on what Mr. Easton had said, Paul, in relation to the decision, the questions asked by the taxing master when a bill comes before him. Say, what is the time frame for reasonable? What is the reasonable time frame for a case? For instance, in considering the bill at the end of it, like, there's cases that go on for a long period of time before payment.
There are, particularly in civil cases and clinical negligence cases, they can go on for many years as a case, and then the bill is drawn. I think by statute the bill should be submitted within 6 months of the case being concluded. The taxing master, in appropriate circumstances, has a power to extend that time. My experience with the current taxing master is that she is proving somewhat unpopular by trying to drive through a principle that bills should be submitted much more quickly than historically they were.
I think you picked me up wrongly. What I mean is, if a case is prolonged for an excessive amount of time, who's responsible then? Who sits then and goes, well, this case surely could have been completed a lot sooner?
That's if they drag the case out.
Yes. So who determines that?
Well, there's two.
And what happens when there is a concern that was the case?
Well, there's two answers. One, standard fees, which couldn't happen because a standard fee, it doesn't. If you drag the case out, you're working to your own disadvantage. So that's really the best solution. The cases that go to the taxing master, as Paul said, the three things the taxing master has to decide: was the work done? Secondly, was it reasonable to do it? And thirdly, was the amount of time spent on it appropriate? So the taxing master specifically looks at that.
So, and I apologise for picking you up wrong, Mr. McCrossen, but effectively, the taxing master, if she sees a number of court hearings and there is evidence that there's a court order that there was such a hearing, she's not disputing the necessity for the court hearing, because that's the judge who has oversight of the case that has deemed that to be necessary. What she's saying is, the work that surrounds it, was that necessary? Was that appropriate in the greater scale of things?
I'm just trying to get my head around this. In relation to, so if there's a case ongoing and say it times out for the minimal fee requirement, and then it goes back to court and the judge allows for a legal aid to be re-awarded again, how many times can that go on? How is this monitored? Because I'm aware of cases that have been ongoing for a long number of years, that has been reconsidered for legal aid and re-awarded for legal aid, and this has gone on and on and on and on. So who monitors that?
No.
Who says that that's reasonable or not reasonable?
I want to try and answer your question this time rather than misunderstanding it. The way I'm looking at this is, when we award a certificate for legal aid in a civil case, that certificate either says on its face that it's to take certain steps or go to a certain point in the procedure, or it could be unfettered, that it's to run the case. So therefore, we wouldn't be coming to re-examine that unless there was a limitation on the certificate which had then been reached, and someone is coming to us and say, well, here's the evidence that I can go further, and we would, it's not a new certificate, we're simply extending an existing certificate. There can be a variation on that where a case has been decided in court and then someone ignores the court order or disobeys the court order, and someone has to come back to get legal aid to try and enforce the right. But those are two separate and distinct pieces of procedure, and there are two separate certificates. I'm not immediately thinking of a scenario, Mr. McCrossen, in which we have stopped legal aid and then granted it again for the same case. That would probably be because the legal aid certificate was suspended for some reason. Now, that suspension is more likely to do with financial eligibility than it is to do with the case. But if there's a stop-start, it's either going to be because we had a limitation on the certificate to satisfy ourselves that it was appropriate to fund it further, or there was a suspension because there was some issue about financial eligibility. But perhaps if there's individual cases, we could take it up in a way where I could talk about them rather than in this rather generic way.
Daniel. Before I go back onto the fraud issue, just the issue of the taxing master. Who is the taxing master accountable to?
Well, the Chief Justice would be, as head of the judiciary, the taxing master would would account to. But the taxing master is a judge, and the taxing master has a legal duty to protect the legal aid fund. That's one of the established principles. The taxing master's job is to determine the appropriate remuneration for undertaking a piece of work, and where there's some element of doubt, must always decide in favour of the person paying. And in this case we are talking about this afternoon, that's the legal aid fund. So if there's a benefit of a doubt, the taxing master must decide it in favour of the legal aid fund. I don't think the taxing master would ever discuss individual cases with the Chief Justice, but every judge is accountable to ultimately the Chief Justice as head of the judiciary.
And what relationship then does the taxing master have with either the department or the agency?
Well, they're an independent judge, so the relationship is simply that the legal aid legislation has provided in the past for the taxing master to assess the fees for certain categories of work. So they don't account to us for how they go about that. We have, where a legal aid fee is being assessed by the taxing master, and that's, as we've explained, increasingly rare now because we're standardising fees. But in those cases where the taxing master is by law required to assess the fee that should be paid, we have, as a department, a right to intervene, and we have done that. We can send someone to make representations if we are concerned about the particular case.
How often would you have done that, David?
More so in the past when we had those very high cost cases, but Mark, I don't know if Mark wants to say anything about that.
We haven't done it recently. As David said, it applied mostly in relation to the high cost cases under the previous scheme.
Just on a practical point, the power to intervene, when it has been used historically, has been used in cases where there's a precedent that is to be set, or where there's something that would be repercussive because perhaps an issue is being discussed for the first time or an approach is being discussed for the first time. The taxing master would then have tended to say, well, there's a public interest to use that general expression as to how this should be conducted, and that's where a right of engagement is involved. The vast majority of taxation cases, to be perfectly honest, will be done on the papers that are available to it, and the department would actually have to stand and read all of the papers and understand all of the issues to make representations on an individual case. That's why historically the interventions in civil have been aimed at strategic issues which would have repercussive impact in terms of civil remuneration, Chair.
And so it's more on the workload, Paul, than the value, is that?
Well, it's on the value of the point that's being assessed. So if you have got a taxation bill which is for £5,000, that may have no repercussive implications whatsoever because it's just a standard case with standard factors. Whereas what I'm suggesting is historically it has been a case which would have novel factors which could create a new financial precedent in terms of how cases were assessed and remunerated. If I can give you a practical illustration of it, because it's a matter that's in the public domain. A number of years ago, a not-for-profit organisation that was entitled to do legal aid work had been refused their profit costs, their uplift on their basic running costs by the then taxing master, because it was effectively a charity. So the taxing master's view at that time was that couldn't get a profit cost uplift. The department at that time did intervene to say, well, the point is that there's bodies that are non-governmental bodies that are very experienced in certain types of law and take test cases, and they should be encouraged to do that. So there was an intervention in the taxation which went before the High Court, and there was then an order which effectively created a rate for non-governmental bodies that are entitled to do legal aid work. That's a sort of structural precedent issue that has been engaged in the past.
So is there any interaction, as either accounting officer for the department or the agency, is there any interaction with the taxing master between either Nick or Paul? Do you have any
He's an independent judicial figure, so there's no direct interaction with me. It is the structure of the legislation that governs the relationship.
And the interaction with me is an operational interaction, because the taxing master, when she assesses a case which is a civil legal aid case, effectively sends me an order for me to treat as an order of the High Court and to pay out money based on it. There are other contacts in which we will provide information to the taxing master if she would require. And on occasions, we might refer a case to the taxing master and invite her to look at it because it appeared to us that there was some issue which perhaps hadn't been drawn to her attention, or that we had been surprised at the way it had been dealt with. So it's for a clarification that we would send for a referral.
What sort of financial figure is the taxing master responsible for?
Well, in general terms, and again, each year will be different because it just depends on the volume of cases that go through and their value. In the last financial year, the taxation cost in terms of the payment to the fund was approximately £19 million.
And is that standard over?
It will be within that range, Chair.
Right. Is there any appeal for the non-performance of the taxing master? If any queries about the work that they're doing, is that to the Chief Justice, or?
Well, if somebody's dissatisfied with the decision in an individual case, they can apply to appeal or ask for a review by a High Court judge. So there's another more senior judge.
Trevor,
Yeah, just on the taxing master still. I think, David, you said the taxing master is an independent judge.
Yes.
Does that mean a judge who has been removed from normal judicial work to do the job of taxing master, or is it a part-time job? Or
it's a the taxing master in our system is both the master, it's called Master Taxing Office, and also Master Enforcement of Judgments. So the same judge is the judge in charge of the Enforcement of Judgments Office and the Taxing Office. They tend to have been, I think, up until the most recent appointment, I think I'm right in saying they've tended to be solicitors in private practice who were then who applied for that particular post. I don't think any of them have served as judges in a different court. It tends to be at the grade of High Court Master, so it tends to be the entry level for civil judges, I suppose you would say.
But could the taxing master in a different capacity be involved in court work as a judge?
I suppose in theory they could, but I'm not aware of any ever having been asked to do other court work apart from their own work as in the Enforcement of Judgments Office, where they have powers to issue warrants for the arrest of people and things like that. But in theory, all masters are interchangeable, so the Chief Justice could say to any master, I want you to come in and do some work in the High Court, but I've never known it, because it's regarded as a sort of specialist expertise, I've never known that to happen.
Okay. So there's a selection of masters that could be called on, is that what you're saying?
Well, there are other masters indeed in the past. I think when we were last before this committee, we explained that because of a backlog on criminal legal aid assessments, the Chief Justice had assigned another master to be an additional taxing master. Normally there's one of these people, so for a while we had two. But the normal complement is one, and if that person needed assistance, another master could be drawn in, and that has happened from time to time due to pressure of work or somebody's ill or unavailable.
And just one more. Is it a job that has to be done by somebody with a sharp legal brain, such as a judge, or could it be done by somebody who's independent of the judiciary completely?
Well, it's important they're independent. That's clearly right. I think the expertise required would tend to be a familiarity with the practice of the law. So I think it would, the logical people to look to if you were recruiting into that specialist post, I guess, would be either solicitors or cost drawers who have the other sector, who have this small number of these specialists who prepare bills of cost. So that's your candidate pool, but you have to be a solicitor or barrister of 7 years standing, so cost drawers, with very few exceptions, are not lawyers.
And of course, the other thing Ms. Hunt to say is that a number of these cases will not be going to the taxing master in future because the introduction of standard fees obviates the need for that. Now, I think you touched on exceptionality, which may be a different issue in terms of truly complex cases, but for the standard cases, they can be administered without reference to the taxing master.
Okay, Robbie?
Yep, just 2 questions, Paul. I think they'd be directed to yourself. I'll ask them both together if that's okay. They won't be terribly taxing, I don't think. On the taxing master, okay. So, have the department assessed the value of reductions at the claims by the taxing master? And then, where do the department draw the line between amounts that are overclaimed, so that obviously the taxing master has found that it was overclaimed, and when that would be fraud? So, what is the distinction from the department's perspective?
Okay. Well, taking the first question, there was a sample done for a period of time for a purpose which has nothing to do with this issue. It was just to monitor bigger cases that were coming through for payment, and this was in 2014-15 into early 2015-16, and there were about 190 or so payments that were made on foot of taxing master certificates at that time. We had a look at it, and it appeared that the taxing master had taxed off something in the region of £2 million of the claimed value. As a result, the claim value was around 15 million. There's a technicality to do with a 5% deduction, which I'll not bore you with, but if we take it as a general figure of about 15 million, taxing master would have taxed off about 2 million of that, and we would have paid out therefore the resultant 13 million. The greater majority of those cases were taxed off at sort of under 20% of the claimed value. And again, this goes back to the point that I was making and Mr. Lavery was making, that a taxing master can look at a piece of work and say, well, yes, I see evidence that you did it, but I'm not convinced that if I was a privately paying person, I would really have told you, yes, go ahead and do that. And that's where the safeguard of the fund comes in. It's not to say that the work wasn't done. It was just the taxing master could take a view she wasn't convinced that that was necessary work. Now, the solicitor can go back and challenge that and can say to the taxing master, here is why that was necessary, and the taxing master may be amenable to heeding that. So that's generically an answer to your question. The second issue is quite problematic because the taxing master has said that the work was done, and she's allowed what she considered a reasonable amount to reflect the work that should have been done. Now, if she was saying to me, I saw no evidence that that work was done, that to me is an evidence of fraud. What she's saying in terms of her certificate was, I'm not convinced that that was necessary work. But if the individual can establish that the work was done, I think that is the difference.
Okay,
just to finish that one out then, so basically it's the taxing master will value the work, and is there no standardised fees? This is the difference between criminal and...
Yeah, for the cases that the taxing master deals with, by definition there is no standardised fee, but as my colleague Mr McGugan was saying, for example in family there will be all of the High Court actions which involve children or divorce or ancillary relief for monies after divorce. All of those cases would currently go to the taxing master for determination of the proper bill, whereas the proposals that are being brought forward and be before the Justice Committee in the course of the current year will be that those cases, the greater majority of those, will be a standard fee model, so they will not then go to the taxing master.
But to the extent that there's a standardisation at the minute, it's the hourly rate. The taxing master would have a rate that she would allow for a senior solicitor or a junior solicitor, so there's a sort of a rate for the amount of time. taxing master, once satisfied the work's been done and it was reasonable to do it, might say, well, you should have had a junior solicitor do that, so I'll just pay you the junior rate for that. That's what they might decide. But there's a standard hourly rate that the taxing master sets for different categories of fee earner.
All bore me with the 5%.
Well, you never ask an honouric question like that, Chair. There is a provision in the 1981 legal aid order that says that if you do legal aid work, the taxing master will assess the work that you did. So let's say 10 hours at £100 an hour. You might think that you multiply 10 by 100 and that's what you get paid. Well, you multiply 10 by 100 and then you reduce that by 5%, and that is a statutory deduction that is made in all legal aid payments, almost from time immemorial in Northern Ireland. It used to be a higher percentage, but it's been about 5% since the 1980s. And I suppose the concept, although the concept is hidden in the mists of time, the concept is that it's almost like a block buyer's discount, that you get legal aid work, you get the guarantee of funding, you know who's going to pay you, you don't have to go to enforcement against that body, so there's a discount applied to it. So that's what the 5% is.
A 5% discount since 1980. Are you sure that just that 5% is now not just added so it can be taken off?
Totally.
What's the point of it?
Love?
Well, it is set in statute as a statutory deduction against tax cases which are paid from the legal aid fund. As part of our work in setting standard fees, we will be eliminating it. So, but our standard fees are going to be based on the research, which is the amount of money which was paid after the 5% had been taken off and not before it.
Okay. So, of the figure you mentioned, 15 million, 2 million of that was taxed?
Taxed off, yes.
Taxed off.
Or reduced on taxation, yes.
What would be the main reason for doing that? Because it's a 13% reduction of a legal bill every time, on average.
Well, each case will be determined by the facts of the case as presented to it, Chair. So forgive me for generalising, but I suppose that's all I can do at this time. The taxing master may look at a piece of work and decide, yes, I accept that you should have done that piece of work. I think you could have done it in a shorter amount of time, so I'm taking off a number of hours for doing it. Mr. Lavery gave the illustration of the amount of the type of work that was being done didn't require a senior lawyer to do it.
I'll ask another way then. For that 2 million that's been taxed off, is there any work done to look for repeat offenders?
Good customer?
Effectively, I have got an order of the court which I pay at that point in time. I will not have seen the full rationale behind the taxing master's decision, so I wouldn't be in the ideal position to decide what a repeat offender would be in that context, Chair.
Well, somebody that continually gets their bills taxed, how would that do for an explanation?
Well, everybody that does the case has to get their bill taxed. They don't have...
Sorry, we'll reduce them. Sorry. Obviously, by the look of the four at the end of the table, no, there's not. Is it something that the taxing master would look at? Does she have repeat?
I can't speak for the taxing master. My understanding of the legislation is that she will look at each individual case on the facts presented against the taxation authorities that are before her.
Okay. Declan, back to fraud. Oliver.
Just quickly, then is there a situation where you could put your price up 5% to allow for the deduction of 5%? Now, I'm not saying that there's that's going on, that fraudulent bills, but is that a possibility that you know you're going to get 5% off, so you put it up 5%?
I think the honest answer to that question is you have to provide the taxing master with the evidence of the work that you have actually done.
But if she's taxing you and saying that you should have had a junior instead of a senior, or taking hours off with too many hours in, your argument doesn't stack up. There's nothing to stop you putting it up 5%.
but the 5% comes off what the taxing master has finally settled the bill at in terms of the number of hours which was considered appropriate in the circumstances of that case, and the level of the fee earner who should have undertaken those hours. So if you have inflated your hours, it will have been brought back down to where it should be in terms of the amount of work which was appropriate for the case, and the 5% will come off it after that.
Sorry, Mark, let me just cut across you. I think the other point is, I wasn't wanting to go into the 5% because it's going to be removed, by the standard fees. I was just, as the chair invited me to humour him, I did so. But in reality, we're not making an offence, Mr. McMullen, for the 5%. We're just saying it's part of the regime at this point in time, but it won't be under the standard fees which are being brought forward.
Sorry, Mark, just a comment you made there. If the hours were inflated, is that not fraud?
Judgment.
Perhaps, the suggestion coming from Mr. McMullen was, could you not inflate the hours in order to do it? So what I was articulating was the assessment that the taxing master makes in terms of the bill which is being presented and the number of hours work which is involved in that, whether that's considered to be appropriate or whether a lower number of hours would be more appropriate for whatever reason.
I suppose back to my former question, is there no sort of repeat offenders to somebody who may continually have their hours reduced by the taxing master?
Well, one might imagine a taxing master over time will look more critically at bills presented by someone who might do that.
And you have no idea if they have, David?
I have no idea whether they do that. I'd be very surprised if they don't look more critically at some bills than others. There's no published information on it. I mean, the way the system is meant to work is whatever happens at the claiming the payment stage, the taxing master makes sure that the payment that's actually made, not the amount that's claimed, that's actually made is correct. And that's why Paul says it's an order. He then pays it without questioning it further, and we don't look behind the court order to the process that led up to it. All I'm speculating, Chair, is that I would imagine that a taxing master over time might be inclined to look more critically at some fee earners than others if they had found that they were habitually having to reduce, say, amounts of work claimed for doing, if it appeared that bills were being inflated in any way.
Trevor, and then Oliver quickly on this point.
Well, just to say that the taxing master sounds like a nice job, because it's a very subjective test, what they apply, and I'm curious what their new role is going to be once we go to standardised fees. And I'm sure people are envious of the role that a taxing master has.
It's an onerous judicial post. And
I'm sure it's well paid.
Beg your pardon?
I'm sure it's well paid.
Taxing masters are paid, I think, like any other High Court master. I think they're paid about £106,000 a year. I think that may have changed by about 1% recently, but all masters of the High Court are paid a salary recommended by the Senior Salary Review Body, which advises the government at Westminster. So judicial salaries are the same throughout Scotland and England and Wales and here. And they're at Group 7 and they're paid the same. All masters are paid the same, and district judges are paid that as well.
Okay, Oliver?
Just, we see here that there's 30-something cases still not paid, and legal aid something like 22 million.
Right.
Is that 22 million before or after the 5%?
Sorry, where are we?
Just which paragraph, Mr. McMullen, if you have it?
I have it here somewhere.
Paragraph 5. Thank you, Mr. McMullen. Appreciate it. Sorry, I think that's a different document, Mr. McMullen, from the one we were looking at.
Is this the...
It's not 2011.
It's the PAC 2011.
Yes, sorry, I think this refers
That's
to
VHCCs.
This refers to old VHCCs in the Crown Court. Now they have effectively, sorry, thank you again. They have effectively been discharged from the system because I think that was the burden of the 2011 hearing. No, they wouldn't have been subject to the 5% because they were criminal cases. The 5% in itself only applies to civil cases, but those cases have been discharged and we're not engaged in the civil taxation process at all.
We have no unpaid legal cases.
Well, in terms of that particular reference, they were to very high cost cases, so I have no very high cost cases which I am awaiting bills for. There are a couple of cases where counsel was clearly in the case and stepped out of it because the case has been disposed of years ago and a bill hasn't been submitted. So I do have a small number of the residual cases in the Magistrates Court which have been abolished in 2009, but the end of those are coming through the system at the moment, but it's a very modest sum of money that's in the system.
But now that you've drawn it to our attention, I remember that exchange, and it was about, as Paul said, very high-cost criminal cases which we had abolished, we told the committee, and they said they were concerned that there's still some in the system, in the pipeline. They were assessed then by the taxing master, but they weren't subject to the 5% statutory deduction. That didn't apply to criminal legal aid, but they're all out of the system now.
And I have a figure if it's of any assistance to you, Mr McMullen, that in 2015 the sum total that was paid for old, very high cost cases in the Crown Court was £300,000, and that was the drain of the old cases, the final ones coming out for payment.
And so, sir, Chair, there's no cases outstanding not paid in any of the courts. Forgive my ignorance of the courts.
Well, if I step back and draw a breath,
Go ahead.
At the end of the financial year at March, we had paid practically every case that had come into the Legal Services Agency. The difficulty is that there was a strike and then cases are ongoing, but we haven't received bills for them. And when we receive bills, we will pay them. There are other cases which have finished and are being prepared for taxation. So there are cases that are just in the normal churn of business. But I think that was a very discrete point of high-value cases that were outstanding for payment. That principle doesn't apply. What we have got now is just the normal run of business. Somebody finishes a case, prepares their bill, it's submitted, and it will be paid.
Okay, Declan.
Thanks, Robin. And just going back on that, I don't intend to dwell on this, Robin, but for the record, the answers to the previous questions were largely based on supposition in relation to the taxing master. They do have control over a budget of up to 20 million. There is no mechanism in place to provide what I would have considered to be the necessary line management that would be required in any form of administration of public funds. So there's actually a fault line, to come back to a term we used earlier, between all of yourselves and the taxing master, and then in relation to how we would in fact then assess the performance of the taxing master in relation to her onerous responsibilities in this matter. So I'm just marking that up, that if we are in fact to continue to have a taxing master, then it seems to me that we need to get a bit more joined up in relation to what the function and the accountability of the taxing master would be, particularly when we're talking about very significant amounts of public funding. Could I draw, and you're all very welcome by the way, could I draw your collective attention to paragraph 5.2? The ongoing qualification of the accounts since 2003, which we've referenced earlier in this meeting. And in that section of the text of the CNAG report, we note the absence of a documented counter-fraud strategy up until 2009-2010, and then the introduction of an improved strategy in 2015, which remains to be properly embedded. Now, that to me would suggest that there are significant flaws in the management systems within the agency. And This is probably a question for both Paul and Nick, but I want to know, do you find that acceptable? And it's probably appropriate then just to tap onto that question as to the acceptability of that situation. Why in 5.4, the next paragraph, does the report find that there is no robust counter-fraud culture within the agency?
If I respond first, was kind of just on the point of acceptability. No, it isn't acceptable if appropriate fraud arrangements aren't in place, and the fact that the agency's accounts are qualified, and on a slightly different point, the department's accounts are qualified, but not on this specific point. But I know the agency, and before that the Commission, has been doing a lot of work on its anti-fraud capability, both on the practitioner on the practitioner side and on the claimant side. The creation of the agency was also the opportunity to bring in this new and benchmarked counter-fraud strategy, which is an improvement on its predecessor, but there had been improvements in the intervening period. Paul can speak in detail about the specific measures being taken, but I'm commenting now, just to make the point, it isn't acceptable.
And I'm rather comfortable with it as well, Mr. Kearney. There has been a considerable amount of work done within the Commission as was, and now the agency to address fraud. I think the CNIG recognises that, but says we're still a way to go. I accept that. The new policy is being embedded. I think the CNIG was commenting at the point of his review. I trust, as other reviews continue with our annual accounts, that there will be an increased amount of confidence in the culture that is being developed, in the documentation that is there to support the work that is done, and to move that on in a constructive manner. I think colleagues within the agency are very alive to fraud, and they are diligent in trying to establish fraud. I go back to a comment I think that was made to Mr. Easton and Mr. Lunn earlier, that what we really need to move us forward is the implementation of our digitalisation strategy, which will enable information to be trapped and analysed in a way which, to be candid, it is not possible to do on a paper-based system with the volume of claims that we currently receive.
It's certainly not possible when you've reduced the number of staff available to be involved in fraud detection.
Well, I accept the observation in the report and your reference to it, Mr. Kearney.
Is it an observation or is it a fact?
Well, it's a fact, and I certainly haven't disputed the fact that it is so. But as I said, we need to target resources, and we're doing that in a way at the moment which tries to break us out of a small team that gets inundated with referrals. They have to be investigated, and they can't get on the front foot and into a proactive mode. That's why I referred to the development of the compliance and registration scheme to give us a greater span, a greater perspective of what's going on, and greater resource to address these issues, albeit perhaps in a different way from what we have historically done. But that is a commitment I give to the committee, because it's something we're working hard at and we're determined to move forward.
Okay. Systems are one thing, culture's another. You don't have the systems, but where's the dynamic coming from within the agency and the department to create the culture? Change the mindset, get the focus right. Where's that coming from?
It's coming from me, and it has to come from me, because I have to give a leadership in this, because my colleagues are aware of these issues. They want to be able to deal with them and to deal with them in a proper way. So we are going through a programme of work at the moment where we are looking at how our documentation can be improved. We have had discussions with colleagues from the Northern Ireland Audit Office about that. We're putting those in place, we're tracking it. That goes to the issue of establishing an estimate of fraud and error within the system, and there is an active programme of work to drive that forward, and that will continue with our current complement, and it will be enhanced when we have the registration scheme to supplement that.
And can you time frame that for us, Paul?
Well, I can.
We've been at this a brave many years.
We
look at things.
We have, and I think I would also say that no matter what we do, we'll still be at it because things change and we need to change. So if we accept that principle, we are working, as Mr McGugan said, to the introduction of the compliance and registration scheme in the course of early 2017, and we will be, as part of that, visiting sisters' offices, and we will be doing our initial round of inspections, and I think that directly goes to a culture within the organisation because we will be sharing information with the compliance and registration scheme about the payments and the concerns that staff may or may not have about individual firms. We are, sorry, you could have for me to continue, so
yes,
I didn't want to interrupt you. We also are in the process of refreshing the complement of staff that we have, and that's actively being done at the present, and we will look to grow that capacity in a number of different ways and get more people available to the team who are trained and accredited in fraud investigation, hence my reference to the joint working with the Department for Communities, which has a significant body of trained investigators, and we want to tap into that resource with others. And the other thing that we've also done is contacted the Central Counter-Fraud Unit, because while the majority of cases that we look at can be dealt with by properly trained staff within the agency, there may be cases which emerge which we need additional experience and capacity to bring to bear on, and we will be referring those cases and helping take that forward with the central unit.
Now, staying with that issue of culture, just if you can indulge me for a couple of more minutes, please, Robin. That issue of culture. There is a reference in the report in relation to paragraph 5.5, which asserts that the eligibility controls which do exist with reference to the detection of fraud focus mainly on the public. So I want to come back and tie that to my observation about culture and mindset. Whatever about the fact that your staffing and resource levels have gone down, the absence of your strategy, the fact that it's not embedded. We've been at this a number of years. 2015 is still to be embedded, and if I understand you correctly, it'll be 2017 before we actually see some headway. My concern is that that indicates, or at least leaves the question, of some form of institutional bias in relation to then whether and how the agency would address the issue of potential fraud by legal representatives. If we already have a skew, a cultural skew, and more of a focus on public rather than profession.
Well, if I can try and address that point, because I want to be absolutely clear that as far as I'm concerned, there is no prejudice or bias. In fact, the greater majority of my staff deal with remuneration of practitioners. Only a very small number of staff actually are engaged in any way with financial eligibility matters in terms of applicant fraud. I made the point earlier that one of the factors which we have to address is that the volume of referrals that we get are from people whose opponent is in receipt of legal aid and they are not. And there's allegations made that that person is inappropriately in receipt of legal aid. Now, those allegations need to be investigated. Oftentimes they prove to be hearsay or absolutely no evidence to support the allegation, but they do need to be investigated. There are other controls that look at the fraud in terms of practitioners that seek to document things, and I confess that the documentation is being enhanced. It's not a perfect word. It is being enhanced as we speak, and that seeks to drive home the issue of practitioner fraud, to give a visibility to the work that's done there, because there shouldn't be a difference. There should be an appropriate response which enables us to detect practitioner fraud as it does to detect applicant fraud.
I was conscious that in an earlier contribution, Mark in explaining the fact that after 13 years the statutory registration scheme is still not in place and hasn't moved on from 2013 because we have to work with the profession. So do we have effective firewalls between the operation of your agency and the department? Do we regulate the relationships appropriately so that, in fact, what you have just said can be embedded in very, very clear and transparent terms?
Can I put my comment, first of all, into context? Because the context in which I was saying that is we had taken things so far with the development of the codes of conduct and our engagement with the Law Society and the Bar Council when we had the strike and the judicial review, and there was a
No, I absolutely have the context of your remarks, and I'm not trying to mix apples and oranges here, but I was conscious that you made the point that it's important to manage the relationship with the profession, and I just want to make sure that in this particular matter we're not blurring the boundaries in relation to ensuring that there is a balanced, impartial, objective approach taken to the detection of fraud, not only within the public but also within the profession.
And I can say from my point of view, there is no blinker. Fraud is fraud, and I don't have friends in the legal profession. I have people I do business with in the legal profession, and I expect that to be the same with my staff, if that's of assistance to you.
Well, thank you. It is of assistance, and can I finish on this point?
Yeah, sure,
I'll give way to others at that stage, Robin. From everything I've heard in the meeting so far, it appears that we are dealing with a systemic failure within the department, within the agency, with respect to management information, which has been touched on in the report, the absence of culture, the fact that we still have an extant effective strategy to detect fraud, and all within the legal aid system. And to be honest with you, I'm astounded that that has been allowed to continue for so long, that we are talking about significant lapses in time. We're still talking about headway in terms of a further 1.5 to 2 years in relation to some of these matters. So I find it difficult to understand how all of that has become embedded within the system, why it's been allowed to go on so long. And I would be keen, perhaps, to hear from yourself, Nick, because you are at the top of the tree here. What are the big ticket remedies to address all of this, and what is the time frame that we can realistically now expect to see this global issue dealt with, fraud effectively addressed in a balanced, impartial, objective way, in order that we're not coming back here in a year's time again to hear that we're making headway, making progress, but we're lacking definitive time frames and outcomes.
Sorry, well, I will pick that up if I may. I mean, in terms of inviting me to comment on sort of the big ticket items, I think criminal legal aid, as I said at the outset, has been a major focus of effort, and I think an area where really significant progress has been made. And talking about any kind of bias or skewing, I mean, the impact of those reforms has been on the profession, not on the applicant. We have protected the ability of vulnerable people and others in this society to access justice. The professions, I think themselves quite hard done by the changes we've made, both on the criminal and the civil side. But in terms of timescales, the next wave of reform, which Mark touched on the civil side, there are 3 phases. An important phase in family law coming into effect next year, and the subsequent 2 phases will take another 18 to 24 months beyond that. So you're looking at 2019, probably 2020 for those for fully to come into effect. In terms of governance, I think governance is stronger than it was 5 years ago across the system. There are some particular measures which will come into effect, I hope, by this time next year. One particularly being the registration scheme, which I think is an important additional weapon in Paul's armoury when it comes to tackling practitioner fraud and providing assurance around that. So there is still a little bit of a bit of a distance to go, and of course sometimes new areas open up. But I think we've made a lot of progress on the criminal side, and we're about to accelerate into significant progress on the civil side also.
Thank you.
Okay. Paul, can I just a point of clarification? How long have you been in post as accounting officer of the agency or its predecessors?
I was appointed as substantive chief executive in February 2010.
2010, so you've been in position over 6 years?
Yes.
Okay. Okay, Trevor?
Well, I think it's Gordon before me, but I'm just sort of surprised
Sorry,
Paul's
Paul.
got no.
Gordon,
just
sorry.
sort of surprised Paul's got no friends in the legal service. That was all.
Sorry, Gordon. My
Thanks,
apologies.
Chair. Just on the point there that has been made about controls and about the various questions were put about fraud. It talks on the recommendation 8 about internal controls are inadequate to prevent and detect fraud. I know we've covered some of it, but it talks about internal controls in the agency have been relatively weak in detecting frauds. The primary control remains the vigilance of staff who process claims identifying anything suspicious, plus a small number of sample-based checks which are largely undocumented. How do you give us assurance that the system is now working when we read this within this report?
Well, there are an extensive range of checks on claims that are submitted, and if I can give you an indication of them, it may be of assistance to the committee. In the magistrate and Crown Court criminal cases, 15% of the bills that are received are checked against the ICOS court system. So there is a complete validation of all of the court-based transactions that happen in that context. Likewise, for the advice and assistance, there's a 15% check of those cases as well. Across civil, once each individual case is assessed, again, there's a 10% check of those. On top of that, there's a 1% sample of files called in, which Mr. Lavery referred to earlier.
A 1% check? It talks here a 1% sample check is applied to all payments. In 2013, the agency determined that this testing should cease. It has not proven to be effective. Despite this, it continued to perform these checks. And what sort of assurance is that to the public? That you've got a system that's robust and is effective and at the end of the day is value for money. It's not giving the public any assurance or giving the public any real sense that your system is in control. There's evidence that the system is out of control. Would you accept that?
I think, before I come to would I accept it, question, Mr. Dunn, the 1% sample is not the only check that's done. It is the final check that's done. Each individual claim is subject to an assessment, and then there's a percentage check performed by a senior manager on the appropriateness of that check. I accept the comment that the CNAG has made that there needs to be greater evidence of those checks, because many of those checks, as I said in criminal, are done from the ICOS court system. We are addressing that at the moment, and that evidence will be available for the next annual review that is undertaken. So that evidence will be there. The 1% sample, I personally decided not to stop it, because until there was the ability to go into solicitors' offices, that was the next best proxy that was available to me, which was to call in the files. It's an imperfect, but it is the next best.
Have you thought of increasing the percentage? Generally, anyone involved in audit would increase where there's a risk. They would increase it. Have you thought about increasing the percentage of the sample?
What we're actually looking at the moment is adjusting the types of the percentage within individual cases. So there are certain cases which we may call in more than 1% of, but we had to establish a platform originally as to identify what the risk will be. It took us longer to do that than we would have liked, Mr. Dunn. I readily admit that. But in terms of payment, there are extensive controls in place. We want to supplement those controls by going to the source of the information, which is in the solicitor's office, and not relying on bills coming into us. So there is an array of controls in place, and I just
it says within this report, and this report's just hot off the press. I'm just new into this committee, but this report, 21st of June, it talks about internal controls in the agency have been relatively weak by detecting frauds. It talks about internal controls are inadequate to prevent and detect fraud. Do you accept that? Is that a reasonable point that this report is making.
I have to accept the professional opinion of the CNAG, and I have to work to address that, because I want to provide an evidence base which shows that there can be confidence in the public money that is spent on the provision of access to justice. To
that evidence is not there to date.
That evidence is not sufficiently documented to enable the CNAG to reach a different conclusion.
I do find it unacceptable that the talk within the talk about your organisation about checks that were carried out largely undocumented. I find that unacceptable. Do you? That they're undocumented. If something is undocumented, what evidence is there?
Well, there's two.
So it's not no wonder you don't have the evidence, because it's not documented.
There's two aspects to the undocumented, as I understand the report. One is that the checks were performed against an independent IT system of the court service to validate it. We need to then show a printout of the state of play when that check was performed. You can't go and re-perform the check, but I accept that it's our responsibility to have that evidence available when the auditors ask for it. That has been addressed. The second one is in respect of an assessment, and where someone is assessing a claim and they reduce the hours. The CNAG's staff commented upon the fact that there wasn't documented reasons as to why that was being reduced. And that is the twofold aspect of the lack of documentation. Now, both of those are being addressed as we speak. And in the latter case, that was based on the experience of staff who have oftentimes assessed cases for a number of years and have a view of what is typically reasonable in those cases. The question has been put, well, say why that is on a form, and that is being done.
Okay. Just lastly, is there a fraud awareness training system in place for all staff?
Yes.
There is?
Absolutely.
And are you assured that it is in place and it's being carried out?
Absolutely. And it will be carried out again, because it's a rolling programme. You don't get trained once and you forget about it. You get trained when you come into the organisation, and then there are periodic refreshers, and we'll be due for another refresher in the course of the current financial year.
The point has been well made about driving the culture. Is there a fear from yourselves, from the top level, of driving this culture?
No.
Is there a fear of all the repercussions?
No.
And the kickback and the risk of disruption?
No.
To the court system? Is that deep down, is that what's wrong here?
No.
Is a fear?
No. I have to administer a system. What we're actually talking about in this section, the case has gone through court. The bill has come out the other end, and we're assessing it. So it is not, I can assure you, Mr. Dunn, a concern about that.
Why is it so slow?
There's a
change in the culture that has been mentioned. Why is it so slow?
I think it's slow because we've been in a state of regular change, and we have regular changes to legislation.
There's not much change within the procedures and the findings that have been found a number of years ago.
I think, in all fairness, there's been a considerable body of legislation which has changed remuneration, which has strengthened the controls by virtue of standard fees and the criteria. There has been a significant body of that in the Crown Court through 2009, 2005, 2009, 2011, 2014 and 15. There's a body of change there, Mr. Dunn, I'd have to say.
Okay, just one other issue, Chair. The management of expert witness costs. In relation to the management of expert witness costs, para 323, page 24 of the report.
Thank you.
Can you explain why the department failed to develop a set fee structure for the engagement of expert witnesses, which I understand as a layman is extremely expensive?
Well, the work is ongoing on developing a standard approach to expert payments, and I think that will come into effect in the course of next year, and Mark has been working on that.
It's probably slightly longer than that. I mean, experts are an essential ingredient in the justice system, both in civil and in criminal, and they're frequently and necessarily employed either as a single expert witness or by both sides of the case. And it is fair to say that it is our intention to introduce standard fees where appropriate, where we can do that. Because there's a body of evidence built up and there's a similarity between the work which is being done, and also to introduce on a statutory basis hourly rates. But I don't think it would be fair to say that the expert witness fees aren't controlled, or the expenditure on experts is not properly controlled. Where experts are appointed, it'll come to the agency that an expert is required, and the agency staff will look and determine if that is the case. Where an expert is to be appointed and the agency is involved in that, they may well seek 3 estimates for the cost of it. So looking at some competition between experts. There are certain bits of work where the organisation has set a general authority because it's a low-level piece of work, getting an A&E consultant's report or something like that, which is relatively standard. So there are elements in there which are standardised, and where bills ultimately come in, they are checked in detail by the agency to ensure that they met the original criteria. If the proper authority hasn't been sought, the agency has the power to refuse that. Now, we want to put that on a firmer footing, and moving forward, our plans are based on a rigorous examination of the history and where experts have been used, how they've been remunerated, the types of work which they're doing, to try and standardise the fees so that it's more readily identified. If you come and do a piece of work necessary for the court, that there'll be a standard fee set for that. It's not going to be possible to do that in all cases. In some cases, the work may be variable, and in those cases, we will be planning to put in place hourly rates. And in relation to that, we'll be looking at the experience in England and Wales as well. Where they have already gone down that route quite recently.
Is it possible to go out to tender for such work?
I think the practice which the agency have undertaken to require solicitors to get a number of estimates is a similar process to that. I think last year or in any given year, you may well have 150 different types of experts involved, ranging from psychologists and psychiatrists through to ballistics or whatever it happens to be. So there's a wide variety of things, and to do a tendering process for that would actually be quite challenging, because there might only be 1 or 2 experts in a particular field, or you might call on them for only a small number of cases.
The other practical point, if I may add, Mr. Dunn, is that one of the issues is availability of experts, because if a court, for example, in a public law children's case where a child is perhaps being dislocated from its parents, and whether that should be a permanent feature or they should be returned to the parents is the issue. One of the things that the court will ask when an expert is being engaged is how quickly can that expert take up that case, because if they're not available to take it up in a prompt timeline, the court won't allow them to be engaged, because that will be to the detriment of the child. So I'm not saying it's impossible to do, but I think there are very practical issues about the promptness of availability of experts, particularly in very vulnerable things like public law children's cases.
Do you feel there is support within the legal profession for changing to a system of set fees for expert witnesses?
As long as the experts have the standing to represent their client, I think that's the issue that the legal profession will have. The legal profession hate the fact that we ask them for 3 quotes, because that's something which slows down getting their case on.
But even us as MLAs, if we want some work done in our offices, we have to produce
Absolutely.
It's public money, it's accountability. It's evidence.
That's why we do it.
Evidence we talked about.
That's why we do it.
Yeah,
So
they may hate it, but
they have to do it.
they seem to have a lot of flexibility in the way they do business. But, you know, they have to start, I think, complying with regulation, perhaps.
But I want to make it clear they have to provide the 3 quotes.
Yeah.
So I think in that sense, as long as we have a system which ensures that we've got the breadth of experts that we need to undertake the range, Mark referred to 150 types of experts. You'll not use the same 150 types of experts every year, but there is a wide range of experts that are required across the justice system.
And I think, going back to your original question, Mr Dunn, I think you'll have mixed views within the legal profession and among the expert community as well. Some will see the advantage of standardised fees, that they can go out and potentially obtain their expert evidence and their expert witness more easily, and others, depending on the types of case that they're dealing with, that they might find it a challenge because the expert may not be available for the standard fee which is there. So I think there will be mixed views on that, but and many will welcome it, I would suspect.
Okay, it did mention the report about, the auditors have examined a number of legal aid case files and found that different experts charge different rates for reading and reporting, for example, the same medical reports. So that's a real risk.
It is an issue for us to deal with, and one of the issues about a standard fee is that you have to identify what is the appropriate rate for that, because effectively, I think the example that's being quoted is about a very senior consultant who would be acting as an expert, and someone who is much more junior. Someone who's much more junior is charging a lesser rate to read it. Now, in a sense, that's no different from a senior solicitor being charged out to you as a privately paying client at a different rate from a more junior solicitor. So there's an extent of logic behind where people pitch their fees as they come into the marketplace, and the standard fee approach will remove that as well. So there's another side to the introduction of a standard fee.
Thanks, gentlemen. Thanks, Chair.
Thanks, Gordon. Paul, who conducts your fraud training for you?
We had effectively a senior member of staff who was a trained investigator and had a background in investigation, and they did it. We're going to outsource that in the next iteration, just as a part of a refresh, to get a different pair of eyes to come in and assist us with it.
Okay, so when was the last time that training was?
I think it was early 2015, but it was last year. It was early last year.
Early 15. And when will the independent trainer be in place?
We would envisage that happening in the last quarter of this year.
So that'll be the end of 16?
Yeah.
So you mentioned continual refreshment,
Yes.
but that's not actually in place at the moment?
Well, the person who trained unfortunately has retired, so we need to find an alternative source of that expert
That
training.
wasn't part of the succession planning within the agency?
It is part of the succession planning, and there's a recruitment exercise going on. The person just decided to go a little bit earlier than was anticipated.
Okay, Trevor?
Yeah, just following on from Gordon, in terms of the standardised fees or tendering, is there a resistance from someone within the department to actually go down that particular route?
The standardised fee route?
Yeah.
Absolutely not, no. It's
just, if I draw your attention to paragraph, page 25, paragraph 3.27, where it talks about a piece of work, a consultation with the stakeholders begun, and then it's suspended for 2 years because of all the priorities. What other priorities would have overtook actually something that could have reduced costs?
Reducing costs. The attention at that particular time was in relation to looking at the Crown Court fees. The review of the 2011 rules was being undertaken, and that was identified and would save significantly more than because it was a bigger budget.
So why did you start the process then, Mark?
Well, to be honest, it was me that stopped it. It had been started by my predecessor. A piece of work had been done on it. We needed to divert the resources when I came in to the other piece of work, we had to prioritise the things that we could do. And indeed, at that stage, I went to the Legal Aid Strategy Group, which we referred to earlier on, and identified the priorities that I would take forward for the next 12 to 18 months.
So it was nothing to do with pressure coming from stakeholders?
Absolutely not, no. It was purely down to how best could I utilise the resource which I had to address the range of issues which needed to be addressed.
Yeah. In paragraph 3.26, which is on page 24, there's reference made to an unusually large expenditure panel. What can you tell us about them, Mark?
Well,
sorry?
It's in my bailiwick, so maybe if I take this one. Effectively, if an expert comes forward with a bill that would be outside, with a proposal for cost that would be outside the norm, we convene a panel of senior officials to look at the reasonableness of it. So that typically happens when you've got a very complicated public law issue, perhaps an expert that's in shaken baby syndromes or something like that that's been suggested from another jurisdiction, and their rates are outside what we would normally pay. So you get a panel of more experienced officials within the agency to come together and say, is it appropriate in this type of case, and does this person have, if you like, a unique expertise which is merited in the case, and then looking at the costs of it. So it's to do with those cases which really just sit very left field in terms of the day-to-day business of experts. The vast majority of experts will just be administered by staff, because they tend to be the same type of people coming back with comparable rates and hours. So that's within the round, but you have cases which just are very unusual.
Well, can I ask you then how often they have actually met?
They meet as and when required. If I was to give you a ballpark figure, I would suggest that they may meet every 2 or 3 months.
Okay. I suppose, and it's maybe unfair to ask you this way, so I'll ask you a question. I'm happy with the information provided. I suppose where I'm trying to gather how often they meet, what the cost of that expert panel is, because there's a cost applied to that, and how much they've actually saved.
Well, we can certainly look to provide you the information. The cost of it will be internal staff time.
Yeah, but you mean you will have applied a cost to that?
Well, we will know how long they met, and there can be a cost attributed to it.
Yes, a cost attributed to that. And then what I would like to see is actually how much they have saved, because obviously that would have been the purpose of their work.
Yeah. I hesitate at that. What they're to do is to say, is that fee reasonable? So it may well be that on reflection, they will have considered that fee is not disproportionate for the complexity of the case. In other cases, they may say, no, we don't think that we could allow that amount of money. So it's not to save cost per se. That may be the outworking of it. It's to satisfy ourselves whether the expert is required at that cost. If you allow my distinction. I
understand the point you're trying to make, but I suppose for me, as a layperson, just like Gordon, where you go to the lengths to set up a panel called the Unusually Large Expenditure Panel, there's an assumption that something's unusually large to be referred to them. Yeah. So there's a cost to that. Yeah. There's a cost to that panel. Yeah. And I would hope that whenever you demonstrate this to us, that we can see that there's actually worth in actually them meeting. But I'll leave that one hanging there for you.
Can I just come in, because it would be part of the internal control mechanisms within the organisation about the regularity and propriety of expenditure.
Well, you have no problem in disclosing it to let us have a look at it in this.
Absolutely not.
That's fine.
Absolutely not.
Okay. Paragraph 3.24 then. And just find where I'd actually taken the note.
24.
So yeah, page 24 again. We're still in costs here, but I'm alarmed, or maybe I could get your view on the last paragraph. It talks about, in some areas, for example, cases involving family care centres, expert witnesses can often be for a high percentage of the total cost of the case. But the CNIG has indicated these were hard to investigate because there was no information. Why have you not got something that the likes of the CNIG can quantify that?
In effect, any expert who is authorised by the Commission, Sorry, am I missing?
I think you are missing the point. I mean, the last sentence says that they were unable to investigate these issues further as the agency was unable to readily supply information of the cost of the expert witnesses.
Sorry, thank you for your clarification. The IT system does not currently capture the costs of experts. I inquired, and it was exactly the same with my colleagues in England and Wales when they were doing the exercise Mr McGugan referred to. We have looked at this, conscious of the CNAG's observation on it, and we have derived a figure which would suggest that on average, the cost of experts is around about 4.6 million. What we can do is strip out known costs, for example, court fees, that would be in the same pot. So we can estimate that as part of the digitalisation programme, that will be addressed, and there will be specific reports available, not only on experts, but on types of experts.
So again, as a layperson, has your organisation got an internal audit function within it?
We receive an internal audit service, yes.
So was that ever identified as a weakness?
It was identified as a weakness in a report. I honestly cannot remember the date of that report, Mr. Clark.
So if it was identified as a weakness and you have an internal audit and you actually have that function, why was it not addressed?
Because it's endemic in the IT system. It will be addressed as part of the digitalisation system moving forward.
I think for the benefit, again, Chairman, of this report, I would like to know when that was flagged by internal audit. Because, again, as my colleague talks about, we've got public money here, we've got something that's been identified, and which you don't have any friends within the legal services, Paul, I'm sure others maybe in your organisation have, and suspicious minds can make us wander all sorts of places. So that alarms me, Chair, that something as serious as that, I mean, given that legal aid has been a hot potato for such a long time, that there's no way for anyone in terms of the audit procedure to drill into that to find out what the value of that actually is, or whether there's actually fraud can be carried on within that part of your organisation.
Well, I assure you I don't have friends within the legal profession, Mr. Clark, but on the serious point, and I do take the serious point, the system requires there to be a proposal setting out the detailed costing of the expert. That has to be approved, and there has to be an authorisation for an expert to be engaged. And then once the expert has discharged their engagement, they have to submit an invoice which comes in with the bill to be paid. The document trail is there on the individual case basis. What we don't then have in place is a mechanism to bring that together by way of a report, which allows the auditors to do an analysis of that, as opposed to looking at individual cases. And I think that's the distinction I'm making.
I'm probably making it slightly different, but I look forward maybe to seeing what you can provide us on that.
Thanks, Taylor. Paul, you receive an internal audit service. Who from?
It's a shared service. It's the departmental internal audit function provides
DOJ?
Our service. Yes.
Okay, and has that been always the function?
No, it was a bought-in service from an independent house that provides internal audit functions, but we received that service, I think it's the third year of it.
So it's 3 years?
Yes.
It's been internal, okay. Declan, you were looking in there?
Just briefly, how many staff do you have under your management, Paul?
Total, it's about 120 at this point in time.
Okay. I referenced earlier the absence of management information.
Yes.
With reference to fraud.
Yes.
Now we don't clearly have sufficiently embedded audit functions, and it just seems to me that the entire approach to management information, how it's harvested, how it's processed, is entirely absent within the agency.
Sorry, I'm just coming on the internal audit function provided by the department. I think it carries out something like 4 or 5 reviews each year within the agency as part of its programme of audits, which is set by the Departmental Audit and Risk Committee. So, and the entire area of legal aid and the risk that represents the department is considered not just by the DARC but by the Departmental Board also. So there's a high degree of interest and a high degree of visibility in terms of the work of internal audit and what it does for the agency. So,
by the department?
Yes, but
and also by the agency's Audit and Risk Committee, because they not only do the Northern Ireland Audit Office colleagues attend those meetings, but so does the head of internal audit within the department at our agency Audit and Risk Committee.
So, what's wrong? Just layman's approach. What's wrong that you can't gather information?
Well, I think there's a weakness in this particular.
At the heel of the hunt, this is ABC stuff.
Yeah, sorry.
You're a very well-heeled department. It seems to be an adequately resourced agency. There is a significant quantum of funds for which both the department and the agency are responsible, and yet we actually don't seem to be able to get the basic information processing functions right, if indeed in place at all.
Well, if I may, we do have management information systems in place. They do operate. Our difficulty, just be candid with you, the difficulty with it is that oftentimes the original design of the system, which is over 16 years old, is not user-friendly to extract information which we want. And we have to work around that. That's why I said we derived the figure for the expert witnesses. Now, the digitalisation programme, which we're currently undergoing, will address those issues so that we do have better tools to investigate and to have real-time reviews of matters, not having to spend an inordinate amount of time trying to extract information from it. It is a legacy issue which we are dealing with.
Trevor, yeah.
Sorry, I'm just combining. This has gone on since 2011. I mean, and if you read the whole paragraph, it's basically saying here, provided all the supporting documentation was there, you just paid the bill. That's, I mean, if I simplify that paragraph 3.24, except when it comes to auditing that, the information is not there for someone to audit.
Well, if there's evidence that the work was done in accordance with the authority that was given to them, we pay the bill. And then it goes on to the system, but it goes on to the system currently in a way which the Audit Office cannot extract a file which enables them to see the totality of the disbursements.
Sorry, it goes further than that, because in your words, you have indicated today that that was actually flagged up by your own internal audit. So obviously they can't see it either.
Sorry, I wasn't trying to say only the external
you only
auditor.
actually referenced the external audit.
Well, sorry, I'm just making reference in the context of this one. Forgive me.
So for me, what makes me more alarmed, you see, for me, the external auditor is your belt and braces. But your internal auditor can't even view this. So, as far as that goes, Chairman, there's no audit at all.
I think that the weakness here is extracting information from the existing IT system. You can do it manually, but it takes a long time to do it. The design of the new IT system will specifically allow this and other types of report to be.
Nick, this report is referring back to 2011 or 2016.
Mm-hmm. Well, and I think the hope is the new IT system will be in place. I'm not sure what the timescale is for that.
Well,
so timescale will be useful now. We're at this stage.
Well, we're working towards getting that introduced in 2018.
7 years.
Nick, you referred to, well, if it's internal audit from the department, you referred to 4 or 5 departmental reviews per year.
Well, I think internal audit looks at different aspects of right across the department, but in this agency, it will look at 3, 4, 5 different areas of the business each year. So it's part of the audit program, and Paul could speak to that. So it'll look at, whether it's creditors or other aspects.
If I may, approximately about 90 audit days spent in the in the financial year, on the audit and the risk.
So, and the risk register coming out of each of those audits is actioned how?
The audit recommendations that are made by internal audit are brought to the Audit and Risk Committee. They're brought with a management response and a timescale to action that, and then the Audit and Risk Committee will monitor that. In fact, the head of internal audit at the end of each year will do a review of it and give an indication as to whether...
Audit and Risk Committee, who makes it up, Paul?
Sorry?
Who makes up the Audit and Risk Committee?
The 3 independent board members of the agency constitute the Audit and Risk Committee. I attend, as does the Director of Corporate Services. Mr McGugan attends as a departmental rep, and then a representative from
Three independent members are?
The 3 independent members of our board: Mr Alan McCartney, who chairs the board, the Audit and Risk Committee, Mr Stephen Wooler and Mr John Morrison.
Can we get a background as well for the benefit of this as well?
We can provide that if that's of assistance.
Okay. Just while I'm on names, your legal aid strategy group, who's in it?
It's I chair it. It's got David, Paul, and Mark, but also representatives from our finance and other parts of the department. So it's an internal operational group as opposed to an oversight group on account of it.
So it's not strategy; it's operational.
Well, it's strategic in the sense it's discussing the strategic direction of legal aid, but unlike an audit committee, it isn't an accountability body. It's
Could we have the makeup of that as well?
Certainly, yeah.
Oliver? Sorry, Carol, did you go in there? Yeah.
Just on that legal aid strategy group, and it maybe was touched on before, how often does it meet?
About quarterly, I think.
Quarterly?
It sometimes meets.
And is there clear terms of reference for that group?
Yes, there are, I think.
And you lead that group?
Yes, I do, yeah.
And can we get sight of some of the things that you've recommended for implementation?
Certainly.
And the ANR group feeds into that legal aid strategy group?
Which group?
The Audit and Risk Committee. Well, the Audit and Risk Committee, its reports will go to the Departmental Audit and Risk Committee per se.
I mean, that route is from their the agency audit committee to the departmental audit committee, which goes to the departmental board. The strategy group is a kind of working policy development group.
Okay. Oliver?
Yes, I want to deal with that very quickly because of the recovery of defence cost orders. We've only had one part of the report here that there has only been one recovery order been issued, and to date nothing has been received.
That is correct, Mr McMillan. The order that was secured for £100,000, the individual appealed their conviction, so that couldn't be executed until the appeal had been determined. Yeah. That appeal has been determined. The person's conviction was not overturned, and that is now in the enforcement process.
What date was that?
I think the order was secured in 2015. I have May 2015 in mind.
Mm-hmm. How long does it take enforcement then to do its job?
Well, this is the first one that's going to go through the system, so I have no history to rely on. Sorry, I just go to, in this case, the individual has assets. Those assets have been identified, and the individual will pay them, but we have to go through an enforcement route to do that.
Surely you must know the roadmap of doing that, even though this is the first one. After all, the system was put in place in 2012.
Well, the enforcement is effectively, it goes to the Enforcement of Judgments Office, who then execute it as a debt.
Yeah, but there must be a roadmap for that there, because, and this whole thing I've heard tonight or today is just we're just limping from one thing to another, and it's, if I have the time, I'll do it, or throw it in here and we'll get it done sometime here. What department you put it into. There's no roadmap here for this here. If this is the man in the street, we owe the debt, that man in the street would know exactly what's happening. And if you really wanted to look at it, you look at the programmes on the TV, they'll tell you how to do it. In this court system, it's all over the place. You know, if there's a man sitting with 100,000 and we have to put it into another department to enforcement, and then it goes, well, where's it going after that?
It then becomes a civil debt, which is enforceable.
And what's the roadmap after that? There goes into the enforcement.
The Enforcement of Judgment Office will effectively interview the individual, deem that he has means to pay the funds, because that is not in dispute, and will then make arrangements to collect the money from him.
Mm-hmm. And what's the problem?
Well, the problem is that that couldn't go to the Enforcement of Judgment Office pending the individual's appeal against this conviction, because if he was acquitted, he would not have to pay the funds.
Yes. So how long would that take then to get the funds off him once everything's done?
It's outside my control, but I'm expecting to get that money in very, very quickly indeed, because there's no reason not to. And if it's not available, then we simply have to go through a debt proceedings.
Why is it outside of your control?
Because I have no power to enforce that other than in a civil context. And that's, you know, as anyone doesn't have power, they would have to go to the Enforcement Judgment Office. If there's a debt owed to you, you simply have to go and enforce it through that means.
But do you not see that as a flaw in your system to speed up the process to get this back in again? Because if you bring in these orders, but you don't bring in the mechanics of delivering the orders, it makes a bit of a nonsense of having the order, because those people out there can work the system.
Well, I think the original intention behind the order was to provide a mechanism in circumstances where it became clear that a convicted defendant who had been in receipt of legal aid had assets that hadn't been declared, and the intention was then to allow the court or the prosecuting authorities or the police to refer that case to the agency. That was the mechanism, that was the policy intent, and the presumption was there would not be very many of those cases. I think there have been 28 referrals to the agency using this order, of which on investigation 27 have been found actually not to, there weren't significant assets there to be seized or to be recovered.
But I think in the instant case, the mechanism to recover the money is there, and it is being applied.
It's just not working. You have 27 orders were put out, and those 27...
No, that's not right, Mr McMillan. There were 28 cases referred for investigation.
27?
No, in 27 of them it was found that there weren't any assets.
This gentleman here said 27, didn't it?
27, but there was, when investigated, there was no means to be seized. But as I said, the purpose behind this order was to allow people to refer cases to the agency.
Who gave the order to have a look at these assets then?
Well, in that particular case, I think the record came from the court itself.
It came from the court, and it was investigated. An application was made to the court.
By who?
By a counsel on behalf of the Legal Services Agency.
And the same counsel, not the same individual, but the same counsel would have given the same order for the other 27?
No, the judge. It's the judge that gives the order. What we found is that there's a statutory criteria which has to be engaged to seek an order.
Right.
And in the other cases referred to, the statutory criteria was not met. For example, one of the criteria is if you're on certain benefits.
Yeah, it's not that all right.
Yeah,
you know.
So we were getting some of the cases that were referred to as were cases that people were on benefits, so there couldn't be an order made against them.
Right, and why are we not looking at means testing?
For criminal cases more generally?
Yeah, any case. Why not means testing them to find out if they have got the means there to pay?
There is an element of means testing in all cases, and we are planning in response to the Access to Justice Review Part 2 to look at that to see whether or not it is appropriate to introduce a hard means test in criminal cases and to improve the effectiveness of it. But in terms of the...
On civil, I mean, Paul earlier read out at some length the financial eligibility test. There's very explicit means test for civil cases, and that's the one. I think in answer to Mr. Clark, we said we would write to the committee with the full details of that. That was the one about disposable income. In the Crown Court, it's the court. In the criminal courts, both Crown Court and Magistrates Court, it's the court that decides whether someone is eligible for legal aid, and an assessment of means form is submitted, and the court makes that determination. What Mark is saying is that we will now look at whether we should introduce a statutory means test. That's what we mean by hard means test, equivalent to the one for civil cases.
But why would we should look at it? Why has that not been done if this is not working? Why are we looking at it now, 4 years after?
Well, I think it's always been the case that the convention is in our law that the grant of legal aid for a criminal case is made by the court, not by the legal aid authorities. That seems to me to be desirable. If you in the Assembly tell us to change it, we can change it. But it's been, up until now, it's been thought important that the decision whether you get legal aid in a criminal case should be a decision made by the court that's going to try you, not by a civil servant in the legal aid authorities. So that the responsibility for applying the means test that applies in criminal cases lies with the court at the minute, and it applies a legal formula, and the law says that if it's in the interests of justice that the person receives free legal aid, then the court makes an order to that effect. The Access to Justice review that Mark's referring to has recommended we look again at replacing that with a statutory means test or eligibility test, and we will do that. But it's likely to slow the throughput of cases up. That's the first thing, because cases would have to be then referred to the legal aid assessment order or some other body to undertake the means test. And my experience is that the majority, the preponderance of people coming before the criminal courts who apply for legal aid tend to be on benefits or something else which will automatically qualify them for legal aid.
What would slow up the system if the majority coming before you?
Oliver, could I bring you back to just some of the things in the report? We're getting down the road.
Aye, but that's what we're trying to... I'm coming to one part of the report here, but I've been sitting very patient all evening. March 2013, the agency received, I'm reading it here, instructions from the authority to stop the practice, as the legislation allows the agency to investigate an individual means only if they merit further investigation.
Yeah.
Could you explain that?
Yes, the department had, the Legal Aid, Legal Services Commission at that time had introduced administratively an arrangement where when someone was convicted of a criminal offence, it required them to again undertake an assessment of their financial means. It did so, I think, with the best of intentions, so that it could identify cases where a convicted person, although they had got legal aid, had assets that should have been disclosed. We advised them to stop that because there was no legal authority for them to do that. The way this recovery of defence costs legislation is designed, it's what Nick called a stop, like a long stop. The main test to see if people have means or not is conducted by the court, which grants the person legal aid at the beginning. This is a long stop that's been put in by the legislature so that if someone is then convicted of a criminal offence and there's a belief that they may have some assets, and that is brought to the attention of the Commission or now the agency, then they can undertake an investigation. It's a reserve power, it's a sort of belt and braces arrangement, but the main test is the one applied by the court when the person applies for legal aid in the first place. And I think it should be, with respect to reassurance to you, that in the 28 cases that were investigated, there was no substance to the suggestion the person had the means to pay it. Some were bankrupt, some were on benefits. There was only one, and that one is subject to enforcement proceedings.
And it states here that they're looking at subordinate legislation.
Well, I think that what we said was we would be undertaking a review of the procedure, and if there were to be a change in it, if we were going to change the practice, it would require subordinate legislation to make that change, and that will form part of the work which we're taking forward. We will take forward during the course of this year.
I mean, one of the Audit Office's first recommendation that's made in this report is that the existing arrangements for recovery of defence costs should be examined by the Department to determine how they can be enhanced to achieve greater impact, and we are undertaking to do that. But I want you to understand it is operating, and it seems to bear out our expectation that most people don't get legal aid for criminal cases who have the means to pay for them. So that must be a reassurance to this committee that the test applied by the court is working, because in the 28 cases examined, 27 of them there was no basis for any recovery.
Do you have any contact with the Assets Recovery Services?
The what is that?
No, the
asset recovery people. Well, Paul, better take that question.
In effect, we have, by saying to them, here's a power, you can come to us if you have got any information on a case. What we don't have is any role in their investigation or their statutory responsibilities. Our role is actually to go to the court and say to the court, this person has got assets.
No.
Sorry.
You swap information. You talk to each other if there's a case there.
I think we can receive information from them. We wouldn't have any information to give them because we have no information about the individual.
Do you ask them for information?
No, and again, that's the point, that the legislation envisages us receiving information, not asking for. We have said we're open for business to people, but we can't go and ask them about it.
So the legislation allows you to take information but not ask for it?
And that's why we couldn't request the information about people's means, as Mr. Lavery.
But what has been done is, Paul's people have been to the Public Prosecution Service and said if there's cases that you suspect the person is as assets that they haven't disclosed, you can bring them to our attention and we can investigate them. And we said the same to the police, and the police have issued a direction or a circular to investigating officers to alert them to this power. So it's not as if we're doing nothing. There is the people who are most likely to pick up the fact that somebody has assets would be people such as the police investigating the crime or the Public Prosecution Service. And the same would apply to an asset recovery agency situation as well. We will review this and see whether further, more proactive steps are required. But the way it's designed, it's working the way it's designed to work, and it works, but it works as a reserve power.
And the last thing is, Chair, the assets you're talking about on the individual.
Yeah.
Does those assets have to be in the individual's name?
I'm pretty sure that's right, but Paul's across the detail.
In effect, that individual has to have the claim on the asset. So there would be an argument if someone had divested themselves of the asset for the purpose of avoiding the order, that we could say that that was what was happening, because that's a standard provision in legal aid. You can't deny yourself assets which you have to get legal aid, and the same principle would apply here. You can't effectively give your dwelling to someone else simply to avoid the charge.
Mm-hmm. So you have somebody living in a house, his name's not in the house, is that his asset if he's living there?
Well, it's not his asset if he's never owned it. I suspect it's the short answer to it. He would have to have a claim to the asset.
I can tell you can drive a coach and horses through this one here. I'll tell you, they're sitting right there, sitting rubbing their hands.
Carla.
Okay, thank you. And I think we're getting near the end. And I suppose I would just welcome you as well. And I want to draw you to paragraph 4.2 4.3 and figure 6. And I suppose just at the outset, kind of maybe to make a few general comments. I am new to this committee, and certainly what I'm hearing today has been alarming and enlightening as well. And I suppose I have to make the point that you're all very educated individuals, and really what I'm seeing, the very, very basics, these aren't getting right. And I think it's actually maybe slightly embarrassing. And I think there needs to be a degree of humility around the fact that the basics aren't right, particularly around information systems and the processing of data. Data is key in today's society, and information is power. And I think the report continuously throughout it highlights the lack of information, the lack of data to back things up. So I really do think there needs to be a degree of humility around that. Paragraphs 4.2 and 4.3, along with figure 6, illustrates that there has been a consistent underfunding of the legal aid system in Northern Ireland. And I suppose my first question around that is, why were the resources allocated to fund the system not more closely aligned to the expenditure levels? So you will see very clearly in figure 6 that consistently the budget is different to actually the actual spend, and I'm just wondering if you could give me some more information around it.
Yeah, certainly. Well, the 2 points I could make at the outset. One is, you're right, there has been a gap between the opening position in terms of the budget allocated to either the Commission or the agency as it now is, and their forecast demand. I would also say at the same time, though, legal aid has been funded to appropriate levels despite major pressure on the department's budget and fluctuating demand levels in each of the years over this period. But the reason for that gap was when the budget for the Department of Justice was set in 2010, at the devolution of justice. It was set for a 4-year period and it was ring-fenced. Ring-fencing didn't mean that it was protected. It meant that the DOJ took the full hit from the Barnett consequentials of the Home Office, of cuts to the Home Office and the MOJ, and we were ring-fenced to protect that, to prevent that impacting on the rest of the Northern Ireland bloc. So that's kind of the background to it. Within that ring-fence budget, the legal aid component was on a downward trajectory from 2010 to 2014, although demand was rising. So as a result, the department wasn't in a position at the beginning of every year to give the Commission what it said it needed. Instead, we moved funds into the agency or the Commission in the course of the year. And we did that for 4 reasons, really. The first was to establish that what they said they needed at the outset was actually what they were going to end up paying out, so to see what the trend of spend was. Secondly, it gave us time to drive out savings from elsewhere in the department, because the police, within the budget, the policing element of the budget, which is 2/3 of the budget, was also ring-fenced, so there was no, you couldn't move money out of the policing side. So we had to drive out savings from the rest of the department. Third, in each of the years, we needed to wait till after the marching season was over to see if the police needed additional resources urgently for operational reasons. And fourthly, we were waiting to see if the Department of Finance might be able to help us in monitoring rounds. So for that reason, we allocated additional resources to the agency in the course of the year. And we managed successfully to do that so that it was able to meet its obligations in terms of paying legal aid. I accept that that caused some administrative inefficiency and inconvenience to the agency, but I think under the circumstances, when the DOJ budget reduced by well over 7% between 2011 and 2015, the fact that we were able to meet the legal aid requirement despite major fluctuations in demand actually was a very pragmatic and in the end successful way of managing the budget.
Okay, thank you. But again, I think it goes back maybe to that whole data issue and the fact that, you know, as a body, were you not able to see that, you know, that it was increasing and the demand was increasing, and then as a result take that back to the department? Or the Justice Minister?
Well, we could see demand was rising, but we didn't have any flexibility to deal with. We had limited flexibility to deal with it, except over time, because, as I say, there was a double ring fence. We were ring fenced from the rest of the Northern Ireland bloc, and policing was ring fenced within the department's budget. So we had to gather up enough money to meet the demand as it developed. So the demand would have been greater if our reforms hadn't started kicking in, about halfway through the period. But that's the reason. I mean, it wasn't. There were some issues early in the period about the accuracy of the Commission's forecast, and that was one reason for waiting to see what the actual spend was developing into in the course of the year. But in terms of, we had the information during the year to take the necessary adjusting action with the budget, but it took quite a lot of effort in each of those years.
Okay, and then moving forward, how in this mandate is it different, or is it formulated differently?
No, it's better. It's now in the sense that the gap between the starting position this year for the agency and the allocated budget, there's been the forecast and the allocated budget, the gap is less than 7%, and I expect, I hope that the reforms we've been discussing this afternoon will help close that gap further. So that reflects better forecasting, it reflects additional funding we got from the executive, it affects the impact of the reforms we've already introduced, and that gives us a more manageable situation.
Okay, and I have just a general question, and then I think Michelle's going to come in, but it's around case management, and I know that some work was done, or this was mentioned somewhere in an action plan around the implementation of a case management system, so that you could actually have better information. And again, it maybe goes back to the digitalisation of the system. Where are we with that? Who's responsible for it, and what way are we taking that forward? I would have thought that it should have really probably been implemented by now.
Well, I would have liked to have had it implemented by now, but we didn't get to that point. We are one of the 16 by 16 digital transformation projects within the Executive's arm, and we're actively working on that with Digital Transformation Services of the Department of Finance. We're finalising a business case to go forward. We've already gone through the process of identifying requirements with our suppliers. We have articulated those, and subject to the business plan being approved, we'll enter what they refer to as alpha stage, the first actual mock development stage in the course of this current financial year.
Okay, so and you're heading that up?
I'm the senior responsible owner for that, yes.
And do you have a team of people around
we
you
do.
then?
We do, and we're supplementing that to make sure that we can deliver that aggressively, because it's vital to all of the things that we've talked about today.
Yeah, well, I think, and I'm conscious that we do need to invest in the system and ensure that we have the system there that works. But I suppose in the interim, it's very alarming. Just the things that have went on and the measures that need to be taken going forward.
Okay, thanks, Carla. Nick, your 7% difference between your allocation and your forecasting, what's the figure?
Actually, Mark or might have that in their head.
7 million. It's about 7 million.
No, what are your figures? What are you allocating and what are you forecasting?
Oh, it's 94 to 101, isn't it? Roughly.
So it's an allocation of 94?
Yes.
So that's up from 75 for the past 2 financial years?
Yeah.
So
Yes.
And it's
Well, I think last year the opening allocation was...
Sorry, I'm so sorry, 13, 14, 14, 15.
Ah, yes.
Yes, 75,
yes.
75,
Okay.
yeah. And you're forecasting how much, sorry, did you say?
It's around 101 million against the 94.
Okay, sorry, Michelle.
Thanks, Robin. Just to follow on from that, that's not really bridging the gap between the departmental allocation and the actual cost. It's your departmental allocation has gone up considerably. I mean, I think it's more in line with what the actual cost is. The question is, why hasn't the allocation?
But the requirement will come down.
The requirements come down a wee bit, but the allocation's gone up an awful lot. That's the...
Yeah, but I think the reality is that to pay for the sort of legal aid system that, based on the current reforms which appears to have, when the current reforms will work through, which appears to have the support of the Assembly, will cost somewhere between 80 and 90 million pounds a year. The original allocation in 2010 had driven the legal aid baseline well below that. So there was a top-up this year from the executive, which brought the core baseline back to a kind of sort of reasonable level, and we are closing the gap between that and the requirement through these reforms.
And how was the top-up managed? Was that through Mandarin rounds, or how did you do that?
Well, it was an allocation in the baseline in the spending. Well, in the allocation for this year at the outset from the Department of Finance.
Okay. Can I take you to paragraph 4.5 and around the weekly payments limits? Because that doesn't seem to make an awful lot of sense to me, that that there was a limit set on what you could pay out. So all claims received are processed, but then that creates a backlog and claims getting paid. Why do you still... I know you've brought the limit up, but why do you still do that? It's really inefficient.
We did it at that particular time simply to make sure that the agency didn't bust its own budget, nor bust the department's budget, while we were trying to free up resources to put into the agency to pay what it needed. So it was simply setting a kind of a regulating rate for payments going out, while we found the additional resources to allow them to increase that pace, and I think that's what happened.
And to go to the end of your question, we don't have that system in place in this current financial year. The increase in the allocation at the start of the year has enabled us to process bills according to our capacity and pay them out, so there's no artificial cap on the expenditure in this financial year.
In terms of unbilled work, the historic cases, and I know we had a bit of a discussion about this earlier on, does the department know how many certificates have been issued and how many are still live?
The answer to the first question is yes, and at the risk of going back into MI, the answer to the second question is that is one of the works in progress that we're doing, because what we find is that a case can be settled. So a legally aided case is settled. It's settled in such a way that the legal aid fund will never have to pay a bill. So there are cases where I should explain that. If you have a road traffic accident, for example, and you win your case, the other side will pay your costs, including your legal costs. So the legal aid fund will not have to pay for that case. But what happens is that the solicitor may not advise us that the case has been won, so that case is still open as a live case in our system. Now what we're doing is going through and effectively trying to purge those cases from the system, and this comes into the qualification for provisions to ensure that we know only the live cases that are there, and there is an extensive programme of work in hand for that. And also, it's one of the features, to go back to your earlier question, is there a compliance regime in the registration scheme where when we go in we say, why were we not informed that this case was closed? Because this has been left as an open liability for us. And I think the solicitor basically takes the view, I'll never ask you for any money, which is true, but there's another side to it, which is we need to close the case down so we don't have to provide for the possibility of having to pay for it.
And can a time scale be requested? I mean, if there are live cases outstanding, surely to God there's something you can do to put a lid on those, to say, okay, that's it. If they're not dealt with by such a date, then you're forgoing the money to that, because surely this is taking up departmental resources and trying to administer.
It is. I think what we're trying to do is come to the same conclusion as you've articulated. I don't think we can do it just as you've articulated, if I may say so, because the case may actually still be before the court. So what we have to do is distinguish between things that differ. There are cases which are before the court and are currently truly live cases. There's cases which have closed and we are waiting the bill, and there needs to be a shortening of that timescale. And then there's cases which are closed and we'll never get a bill, and we need to be told about that by the practitioners so that we can close that down. So there's three distinct areas that we're addressing.
And not confusing. I mean, the third of those three, those need to be guillotined. You know, they need to be taken out of the system. The first one, I accept there may be cases in family law and cases relating to children that are going to be live over a period of years. But one of the things I was thinking earlier when we were talking, this is taxpayers' money, and quite a bit of it, in the region of 100 million per annum. You said earlier, Paul, something about clinical negligence cases, and those cases do tend to take an awful long time. Now that DOJ is around the executive table with the Department of Health, can there be any work done on closing down those clinical negligence cases? Do drag on forever, and the department just seem to be keeping pushing them back, the Department of Health now, to avoid payment. As a result, the taxpayer is paying the Department of Health's costs, the taxpayer is paying the defendant's costs. Double whammy. One case where some creature who has been very badly treated in a hospital or by health professionals is engaged in a legal battle that's taken forever. I know cases, I'm dealing with cases in my own constituency where families are waiting years for these cases to be closed, yet the taxpayer's paying twice. What has been done to ensure that that system ends?
Well, there's no reason that I'm aware of why you wouldn't allow someone to obviously seek compensation in that situation. Lawyers tend to take a longer period of time over a clinical negligence case because they want to see the medical condition stabilise. So these cases are just inherently going to take longer. But the more fundamental point is they're acknowledged to be a challenging type of litigation. The Chief Justice has set up a review of civil justice, which I understand will look at this type of litigation among others. It's being led by one of the senior Court of Appeal judges, and we're expecting to see a report on that. So I don't know what that report will say about this, but I know that this is one of the aspects of civil justice that the review being led by Lord Justice Gillen will be looking at. So there is a review of it. And we as a department are looking forward to seeing what the recommendations are, because I know the judges acknowledge the conduct of these cases is prolonged and problematic. But your question is really, should the government in some way get behind all of this and look at the double whammy, as you call it? I mean, our responsibility is to ensure that a person who has sustained maybe a life-changing condition as a result of alleged medical malpractice has the ability to access justice. We regard that as our job. I think it's important that they have that opportunity. There might be a case for whether the medical defence approach could be reviewed, but as I said to you, I think I'd prefer to wait to see what the review of civil justice says about this. If it gives us some suggestions about improving the process, well and good. I think they will be looking at aspects such as the more effective case management, but I really don't know what their recommendations will be. Our job, though, on this side of the government machine is to make sure that people who have sustained life-changing conditions because of medical malpractice are able to access justice.
And I accept there is such a thing as human fallibility, and people make mistakes. But Surely there are cases in other jurisdictions in other parts of the world where similar things have happened. If the Department of Health were prepared to put their hands up and say, a mistake was made, we accept that. We know from precedents set already what the financial package needs to be, and they were to settle a lot more quickly. I think it's bad enough that your life is destroyed by a mistake, first of all, and then a court case that can take 12, 16, 18 years before it's, and the family is put through all that. Again, that's an incredible situation that can't be allowed to continue.
I mean, there are probably countries where it's even worse. The United States is probably the classic example of expensive medical litigation. You could look in other countries where they have a no-fault system, so fault isn't disputed. What slows these cases down is people not admitting fallibility and a mistake was made, and the case is being defended and fought ad infinitum. So countries such as New Zealand have in the past introduced a no-fault system. So all the person has to do is to establish that their health was changed adversely. And then it goes into an assessment of the appropriate compensation. So they've taken the whole dispute out of the case. But that would, I mean, with respect, that's as much your job as ours. That needs a change in the law, and it is an option. But our system is based on the contesting liability, and we need to really change that. Our department's responsible for legal aid. It's not responsible for that issue.
But the point I'm making is, and I'll close on this, is the taxpayer are paying twice.
Yes, I understand.
They're paying for the department to defend their practitioners, and they're paying for the legal case, and the taxpayer has a double whammy.
And probably all the associated costs of supporting somebody in that condition.
And not to frustrate the chair, but if the legally assisted person wins, health pays for it twice. We don't pay for it.
Yes, that's
which is the other significant point.
Taxpayers still picking up the bill.
But I think there's a motivation to look at how the system works through that prism.
Okay, thanks, Michelle. Carla?
Yeah, just very, very quickly, and again, it maybe just goes back to that whole management information. Paragraphs 4.9 and 4.11 really describe how since 2003 the methods used to estimate the total value of outstanding legal aid certificates is inadequate, and it talks about the undermined by the quality of data available, and I don't want to labour that point, but I suppose a couple of points would just be a few headline points again about how you are going to improve it. What can we expect to improve it?
Well, there's an active working group where the finance colleagues in the department and the agency are working very closely. We have made progress. I think in other contexts the CNIG has recognised the progress we've made. The difficulty with it is legal aid is a complicated area, and I'll not say that again in the course of this session. But what we need to do is try and simplify the assumptions that we make to enable us to have an evidence base to support it, but to do that in a way which doesn't compromise the accuracy of the forecast. So we have got a programme of work going on which, in terms of provisions, deals with the points that Ms Gilmer, you were talking about, in terms of the tail of cases, to remove them. We've got a programme of work which is looking at the life cycle to refine that, because by closing down cases, we clean up the life cycle issue. We are looking at the average costs in a way which tries to bring things together which are the same and keep things separate which are different. And we also have got a programme of work going on which is saying, how do we strip out the cases which we will expect not to receive bills on for legitimate reasons, to make it part of the process. So we have that programme in work. It's ongoing in terms of our next forecast. We'll start to see that coming through, but it is an iterative process because we need to simplify the complexity of the process, but do it with transparency so that it can be audited and the accuracy of that can be assessed.
And when can we expect to see this transformed system?
Well, in terms of the financial forecasting, we're going to have our first effort at that in the October monitoring round, and then we were going to build on that, and the provisions will be enhanced so that there will be work done to address the provisions for the current financial year. Some of the work will extend beyond that into next financial year to deal with the tail of cases that Ms Gilner was talking about, but that will be in the next 2 years. That will be a programme of work, but there will be progress made on each iteration of it.
Okay, thanks, Carla. Everyone content? Yeah, questions asked? I suppose generally still concerned, gentlemen, I suppose even more concerned hearing that now the department's accounts are qualified because of the ramifications of what's coming out of legal aid. So I can assure you it's something that we will be taking a closer look at, and we'll begin into closed session after this session to see if we need to expand out from this evidence session today. Can I just ask our Controller Auditor General if there's anything?
Just to elaborate, Chair, on the provisions issue, that's been a problem for years and years. I'll be absolutely honest, I haven't seen much progress on it, and the acid test of improvement is when I lift my qualification.
Okay.
It's not rocket science, it's capable of actually being cracked. I think Carla's absolutely right, it's about basic management information. So it can be done, it's doable. Needs a bit of work.
Okay, thank you. Accounting Officer?
No, thank you, Chair.
Last time. Okay, gentlemen, thank you very much for your time.
Thank you.
Okay, now all the best.
All the best.
Okay, members, just for final items, can we begin to close session?
This is the Northern Ireland Assembly Senate, Programme Sound.